My lord, may I pay to file the mandamus appeal matter without certified copy?
When was the order passed?
In the part of 26 September. Within a month, my lord.
You applied for
Yes,
certificate?
ma'am.
Please grant it.
Lordship, may I be permitted to mention a matter? May I be permitted to mention a matter?
Yes, yes.
Lordship, the item is today's in the list, item number 11. I am mentioning for extension of interim order because interim order will expire on 16 October.
Who is your other side?
I have already upon notice to other side.
Bring your other side at 2 p.m. If it is not reached by that time, bring your other side.
Wait,
It will expire today.
16 of October.
Bring your other side 2 p.m. And if it is reached, then we will.
Wait.
Yes.
ওর কাগজ এসছে তো তারপর আমাকে আসছে আমাদেরটাই তো
You are appearing.
Lord, I was assisting Mr. Mitro. I was before the single judge. Yesterday, I could not come, Lord, for the College Service Commission.
Where is the special officer? Where is the special officer?
Special officer. Well, he's supposed to be here. But I will just give my lord point-wise reply. As I thought yesterday, your lordships.
You
You
charge
are
me.
for the commission.
College Service Commission.
Please intimate the special officer to be here.
Special officer, খবরদার।
And who is for the writ petitioner?
Lord, for Mr. Petitioner, Lord,
For the writ petitioner respondent,
You are
led by
Mr.
Mr.
Vivekananda Ghosh.
Mr. Vivekananda Bose is on his way here. He's coming, my lord.
On his way.
He's stuck in traffic. He's coming, my lord.
We don't travel by, we do not come in time.
My lord, he's
Lord, on day one, Mr. Bose appeared for the writ petitioner. Then thereafter, Mr. Bhattacharya started appearing for the writ petition.
Where is Mr. Bhattacharya?
Lord, I saw Mr. Bhattacharya in front of him. Maybe he will be joining shortly. Not only yesterday I was following it, Lord, virtually. I was in circuit. Only one clarification, Lord, there was no formal charge handover. Formal charge handover to the special officer or appointment as a DTO. It is the court's order by which he was appointed. There was no formal charge handover. Yesterday, a question fallen from your lordships, whether he has taken over charge or not.
The special officer says that charge has been handed over.
by
Lord,
whom?
By whom?
By whom?
Court has said that you go and take charge. Court has appointed him as the DTO.
Lord,
It's
I will
not
be
that
placing,
nobody,
my lord. I will be placing.
it's not that someone has handed over him charge. It is
Correct.
all the subsequent orders after the appeal is preferred.
Anything else?
No, we have nothing more to say.
Your contention is that charge was handed over by virtue of the court's order.
That's a fact. That's a fact.
By
That's
the order of 5th October.
6th. After the appeal is filed, all the orders are passed day to day by that. And for the commission, Mr. Mitra has made us stand clear yesterday.
Yes, Mr.
Lord,
They complete, I will not take much time because I'm one of the respondent. So he's actually replying, my lord. So before that, I want to complete my answer.
All right. Mr. Shannan, yes.
Dr. Achina,
You are appearing for whom, Mr. Banerjee?
26, Dr. Achina.
Really, I'm not in reply. I'm also fast. I have to make submission. So everything has been said in opposition.
Oh,
Yeah, reply to substantive argument. Because all those have been said not in.
Yes, Mr. Banerjee, what do you want to point out? Your respondent number
26.
26.
Dr. Achina Kundu.
Yes.
Now, my lord, just, I'll just explain some fact which is to some extent relevant for this reason. So my client was concerned. My client, when she was working and as a professor of these institutions, after serving sometimes, my God, she became ill. So she wanted a voluntary retirement. She made an applications, but at that point of time, she was not otherwise eligible because neither he has completed 30 years, 60 years or 25 years. So
When did he apply? When did she apply for voluntary retirement?
that is the first, long back. But secondly, again, there it was pending. Again, it was filed. an application after they say you are not competent to apply because neither you have reached the age of 60 nor you have completed 25 years of teaching.
Yes.
So subsequently, when I completed that, I reminded them, made an applications. No matter that was under considerations. I said on and from that day, I'll not join because her husband was seriously due to brain stroke and other things. So naturally, my lord, uh, they thought that was she must look after her husband because his position was very bad. So she was not in. He was not in a position to come to court. Anyway, then my lord, when it was pending, gentleman who moved this application, the student who moved these applications, there my client was also made a party. Very well, everybody can do that. Whether spirit at all is maintained or not, I'll come later on.
No, we didn't follow. Your client applied for voluntary retirement first. It was not allowed because she did not fulfill the criteria.
Yes, not that it was outright rejected. Said this is the profession unless you cover this.
Subsequently, upon
Again, I
attaining eligibility, you applied.
applied.
Now that what happened? That was not considered.
That was pending considerations. Then my lord, he said very well. On and from there, that is on 31st August. I'll not go to the college. I do hereby tender my resignations.
31st of
August, like
each year,
this year.
she tendered resignation.
Yes.
Very good.
Then my lord, I found that that was also later on I came to learn that application was moved. I was made a party to that. My grievance is this, these petitions. My grievance is this, when certain allegations are leveled against me, they can do whatever they like. But once these allegations are leveled against me, these are a question of fact to be gone into. And I must be given an opportunity to say, no, I am not committed such a wrong. But the day on which it was moved, without serving notice to me, order is passed. Your service is terminated.
No service was made upon.
No. And my lord, the most funny thing is this, my lord, even a person who committed a dacoity, murder, or rape, he was also getting a chance. I appreciate the anxiety of learned court, my lord. I have full confidence in my lord. I yes, love him, respect him, everything. But court has also got its own limitations, my lord. I appreciate that unless he is there, there's such a mischievous activities naturally unearthed, absolutely unearthed by the judge. I cannot, but when this petition was moved, I expected that I must be given an opportunity to say, my lord, I am not at fault. That was not done. Before I
Had no notice, Mr. Van.
oh,
You appeared before this.
I didn't get the opportunity to appear because I was not even served. So before notice is served, order is passed in the afternoon and notice was served in the late evening. At one in the midnight. By evening it was served. And the most petition was served and notice was intimated to me. It's very unusual. So my lord, another thing is this, the honorable justice, you can satisfy in future as if it is review. Then I consider. So that was put the cart before the horse. And my lord, even in this crime, I'm not entitled to have justice. Justice doesn't mean to be political abstraction. It is an instrument to do the justice. To have the justice I expected before taking drastic action against me, an opportunity must be given to me. That was not, that is a fundamental question, my lord. It goes to this case. So if that is so, order cannot stand. So that is I am concerned. I cannot speak for others. So I am concerned, serious prejudice, and as my lord knows better than me, my lord, having a past experience from both sides, especially service matter, my lord. I will service jurisprudence. The dismissal of termination, I would say capital punishment. I have lost my job, of course. One thing is very clear. When my lord is found, when I found the ground, what is happened? Even before any order, any notice, I again reminded them. I say I already resigned. Again, I sent a letter to them, which they received, college authority. So I was not in service. I wanted to have the volunteers that was not considered at all at the still it is pending. And when I found it is impossible for me to justice to the student because I cannot attend the college. My husband is seriously ill. So I have to look up to my husband. So that's why I say, very well, I resign from that. Whatever has been done, that has been done after my resignations. So nothing is there. So how can,
Your resignation was accepted.
yes, that is my lot. I believe.
All right.
Yeah.
We shall record your content.
And
Yes,
so-
Mr. Shan.
another thing is my lot. This is one aspect. Second aspect, my lot, it's the public interest litigations, my lot.
Filed a independent appeal.
Yes, happy because no, because I'm a respondent here. Because if it is decided also in this appeal,
So how can we decide your directions?
no, because I am a respondent.
We will record your appearance and your contention.
But one thing is very clear, my lord. This is not a public interest litigations. This is not about it. The basic and fundamental difference between jury or the non-public litigation.
No locus you mean to say.
And not only that, a person will need have if he got some interest, he can only public litigations. Person having some interest, he can only applications. Let us see how is that reconstruction damage. Normally, the application for stay filed by Mr. Samuel's client. That one, nobody said how and which manner is affected. No damage is at least damage. Damage is the question of fact to be assessed. At least he can claim damage. I have suffered because my teacher was not competent. He has never said that well. I have suffered because I couldn't succeed. I failed. Because my teacher will be improperly. How is it? A person having several degree may not be a good teacher. A person without any property may be a good teacher. Now, my lord, I just cite one judgment. It's very relevant for these reasons. Much has been said about the qualification of the things.
So, Banerjee, this will be a submission in your appeal. You are a respondent, we will record your submission.
No, but
On their appeal, we cannot give you any benefit.
no. Regarding that, my lord is right to move the writ applications.
Yes, we will record you. You
That's why,
submitted.
to that extent, I said just one judgment. Kindly take it well. It's very relevant, which is reported in. Huh? 1993, 3 Supreme Court cases, page 591.
Yes.
Much has been said about this qualification, other things. Here the same thing was happened. Appointment. Fact moral is 7, my lord, because some persons, they are also employees of the college, my lord, they challenge the appointment of the principals. After 9 years, the very same point,
Yes, which paragraph you are?
paragraph 6, is very short judgment, my lord. In spite of the some illegal appointment, court says no, Supreme Court will not interfere. Very rightly, my lord asked him, why you have come so late? Why did you not come immediately? He waited. Since we find that it was a default on the part of the respondents, director of relations illegal appointment, the appointment of the first respondent in 1981, although he did not request its academic qualifications, as a result of which the first respondent has continued to hold the said post for the last 12 years. Now, it would be advisable to disturb him from the said post at this stage, particularly when he was not at fault when his selection was made. There is nothing on record to show that he had time to project his qualification other than what he possessed. Kindly see. He did therefore, in spite of placing all these cards before the selections committee, the selections committee for some reasons or the others had thought it fit to choose him for the post, and the second respondent had chosen to acquiesce of the appointment. It would be iniquitous to make him suffer for the same now. Illegality, if any, was committed by the selection committee and as such. So, my lord, his writ petition was rejected. Against that matter, the Supreme Court said, no, after 9 years, what prevented you to come earlier? It's not a child's play. You are talking about the damage. What is the damage? In the read petitions, my lord, I had a privilege to look at the read petitions last night. Not even a single word is damaged. Fraud is a question of fact. To be pleaded, as you learned since we joined this bar, he must disclose what is actually the fraud. Nothing is. Emotions will not say anything. Emotions will not come to play. And here, if you also take Tapabrata, the judgment is very short judgment. The same fact that some persons of the same institutions challenge the appointment with that allegations without having any proper requisite qualification. He was appointed. Now, court says, yes, even if it is so, we are not going to interfere because
This does not decide the locus. This is
No.
another argument of yours.
locus, now I say locus because it is a public litigations. Once if it is not a, what is the legal right? And if it says, because of this teaching, I have suffered, I have lost 3 years, I could not succeed. What is the statement? What is the statement? It is not a child's play. It is not a child's play. Whoever will come and burn the court with all those things.
Yes,
And why the court will interfere? I don't understand. Because even if there is a wrong is committed, as per Supreme Court judgment, my lord, you have missed the bus. You cannot do that. And certainly, persons at whose system proceeding was initiated, he has got no locus to challenge this because this is not a public interest litigations. It is not a public interest litigations. Even the court, and my lord, very rightly, my lord officer, how can we cancel the part-up? Do you expect I'll cancel the part-up? Absolutely, my lord is absolutely correct. I am not on those points. It is what the bizarre wisdom of the court. And my lord, law is very clear. The
yes,
rest of the master, my lord, the chief justice, what do you think, you think? So this bench, I cannot approach with this, my lord, and I must finally confess. I don't have any personal vendetta, personal grievance against the concerned judge, but the judge has got his own limitations.
he has argued that any personal vendetta
Not that, my lord.
did not make such comments.
So as your justice, my lord, at the same time, at the same time, what I know, that well, what is done,
You have understood yourself.
naturally, it cannot be accepted. So if all those things are taken together, even if I argue on behalf of the respondent, I can draw the attention of the court and I can say, my lord, the way it has been done, it should not be done because law has got its own limitations and law doesn't mean to be a mere theoretical abstraction. It is an instrument to have the justice. I have not got any justice before I'm a hand. So I expected justice to be done.
Yes,
It has not been done.
thank you, Mr. Yes,
Despite that.
yes.
Now, my lord,
On
one
your-
problem was there on that day. Of course, I am also a member of the bar. Though I was not served, if it is not served, I am not supposed to appear. I don't know. But on that day, there was a resolution of the bar not to attend court after 2 recess. So my
Because you were respondent number what in the writ petition?
26.
26,
All right.
26 minutes.
Yes, Mr. Vance. Thank you. Yes, Mr. Santana.
My lord, one thing I must tell you, lordships, yesterday, my lord, I placed the order and took the point that at the very motion stage,
My lord, sorry, just 1 minute. Though it is unreported, following the Supreme Court judgment, your lordship's court has also delivered judgment where my very beloved junior friend, Mr. Bhattacharya, appeared and order is passed in his favor. তুই অ্যাপিয়ার করেছিস তখন তুই ওইটি নিয়ে আর্গুমেন্ট করছিস তোকে যা জিতিয়েছিল বল্লরি সরকারের kindly have a look. He relied on the Supreme Court judgment. It's unreported, my lord.
Yes.
And I had a privilege to read this judgment. কেন তুমি কেস করছো তো?
Yes, yes,
He appeared in argument saying,
yes, yes, Mr.
my
Santana.
lord,
I have taken instructions about the PRS issue. I can assist, but there is also some starting things.
All right. Yes.
my lord, yesterday I placed the order under.
I have resigned, my lord. Why is talking about? As a special officer, he has got nothing to do with that. Why is spoken his nose?
Record to the college.
Yes, they go to the college.
I have nothing to do.
Yeah, I have already tendered my resignation prior to order passed.
Yes, yes.
Why?
Well, I
He is so
just-
biased. General, he's a special officer.
My lord, yesterday what I have said, much have been said by the respondents. I didn't have any opportunity before the learned single judge to deal with that also. Now I will deal with that, your lordships, in reply. because nothing was before the learned single judge.
Yes, that is your argument.
No,
The
that's,
whatever has been.
no,
placed
I
on-
have to deal with that because
No,
record,
no, you need not deal with that because that was not prior to it. That is an admitted Mr. Bhattacharjee also said that this was not before the court on 5th of October. Whatever has happened, that is subsequent to 5th.
now one thing, after all, certain things have been made, certain submissions, but according to me, which may prejudice the mind of the court. I have to, my lord, deal with that and to, my lord, remove that, my lord, if anything prejudice to be caused to the mind of the court.
Yes.
I, my lord, kindly allow me to deal with that because records are before your lordships now. This has to be dealt with.
We are
Yes.
not hearing on merits. We are on this limited
My lord,
ground.
your lordship has heard them, Mr. Banerjee and Mr. Special
I
Officer.
cannot stop somebody from
Now,
making.
kindly do not stop me deal with that.
Yes.
So I will not repeat any of
We
the
are
points.
hearing since yesterday. Make your argument.
I'm point wise. I will not deal with. I'm point wise.
Yes.
No, I will not make any repetition of my argument, but I will deal with them, my lord. My lord, kindly take the order first, 5th October, my lord, the appeal order under it.
We put the question to Mr. Bhattacharjee that all these documents which have come, state affidavit which has come, admittedly that was not before the judge. So that was not before the judge on 5th of October. Whatever happened was subsequent there. And you are aggrieved by the order passed on 5th of October. We were not deciding your claim on merits. Your argument was very short. That on the basis of the assistance was not obtained, the learned judge had a conversation over mobile, and on the basis of that, this order was. This is your concise argument. And in a coordinate bench matter, this assistance not given, and that is why.
Another thing, your lordship, in the coordinate bench matter, that's wanted to make submissions. My lord, didn't, my lord, that opportunity. Kindly paragraph 6. This was not an urgent matter. Coordinate bench had held it.
Yes, yes. We have taken note of that.
Then your lordships kindly consider the other paragraph. My lord, your lordships will find paragraph 9 of the impugned order.
Restraint from intent.
No. I appoint Mr. Orko Kumar Nag, Advocate Special Officer. Well, I'm taking a point. What was the necessity of appointing a special officer?
That is the discretion of the.
My lord, I tell you, my lord, not discretion, your lordship. At any point of
We
time,
don't have discretion.
my lord,
to
I tell
appoint
you, I tell you, your
No,
lordship.
we cannot appoint you as special officer.
My lord, not
Mr.
unless facts are before your lordship that necessitates. My lord, special officer business, Supreme Court has also deprecated in a number of matters. But I'm not on that. I am not on the appointment of my learned friend. I am on the point.
That there
What was
no
the necessity of that?
All right.
Is there anything before your lordship to appoint a special officer? There is an elected governing body, duly constituted governing body. Now your lordships kindly take up your lordships. Therefore, my lord, my first submissions. What before the learned single judge for my removal, nothing was there. This was
We
done.
have heard it, Mr.
My lord, kindly, my lord, I tell you, lordships. Now, this is the point. Now, therefore, that order should not be there. Now, your lordships, kindly, the point arose. Subsequent orders I have not questioned, and there is a appointment special officer. Special officer has taken charge of it, and there is an appointment of teacher in charge, or my lord, the principal in charge. Your lordships kindly have a look at the next date order, 6th August order. Your lordships will be find everything was sought to be produced on 6th. The appointment of teacher in charge by the Honorable Court on 6th. So, my lord, my question, there's a duly elected constituted committee. If I am my removal, if at all upheld, my lord, the governing body will be allowed to appoint a special, my lord, teacher in charge, not by the court, my lord. What was the necessity of this? And I could not, because I have been removed. I have to first, my lord, dispel that order. Then I will make further submissions. My lord, what I am wanted to make, I made that submissions, but I didn't my lord, have the opportunity to cite in the judgments. If the parent order goes, all subsequent orders will automatically go. Your lordships kindly consider this judgment.
No,
I will
that-
cite 2 judgments.
That
My lord,
is
kindly,
settled proposition,
my lord,
Mr.
kindly
Bhatta.
record
Why
that.
you are referring to judgments at the reply stage?
My lord, I didn't have that because everything has
No,
been
yes,
said.
this is a settled proposition. that if the parent order goes, the consequent orders will also not survive. This is
Therefore,
the-
your losses, kindly take note of the judgment, your losses. This is your losses, 2011, 5 SCC, page 142, paragraph 32, 33. At least your losses, I request your losses, kindly look at that.
2011,
2011, 5 SCC,
2020, 11,
No. 2011 follow.
2011, 5 SCC,
11.
page, কত বললাম রে?
142.
142, paragraph 32 and 33. দুটো বই দে। এটা দেখ,
32 and 30.
33. Kindly have a look at this.
শরীর খারাপ।
একটা কপি এনেছিস? আরেকটা এসছে?
এই তো যশোরকে দিয়ে দিয়েছি।
না, ওটা না, নেক্সট। আমি যেটা তোকে কাল দিলাম।
Yes.
উপরেরটা।
Take note your losses, the another judgment, 2000 volume 8, 2000 volume 8, SCC page 395, paragraph 23 to 27, more particularly paragraph 27.
The key point is
Doctrine of consequential laws. Paragraph 23 to 27, more particularly paragraph 27.
Yes,
These two judgments I am citing your losses.
yes.
আরেকটা দেব।
আরেকটা তো
That was referred to in paragraph 33 of the earlier judgment.
That's your losses, consequential. Now your losses, kindly take up the writ petition.
আবার কি?
Kindly have a look at this, how this was moved, my lord.
You have said that. You have said that.
No, I have not said that, your losses. I have not taken.
What
This is the point of locus, the point of urgency, point of making the matter hard in part. Your losses, kindly have a look at this page 61. I will not take much time. Kindly have a look at this, page 60
page 60 of the stay.
of the stay application.
Yes.
Now kindly see paragraph 2. He's a student of 9th semester, the last but one. So he has spent his student life 4 years for the college. He didn't find anything against me. Now kindly have a look at page 5, 67, paragraph 5. How he is prejudiced. Did he say, my lord, that he has suffered because of a bad teacher? My lord, everything should not be allowed, my lord, by this. My lord, what is the allegation against me? That I didn't have net slate. It's not that I didn't have the basic qualification when the college was private.
That Mr. Mithro has explained through
That's your losses.
that he has substantially drawn our attention and made some. Yes.
principal appointment.
Therefore, your losses, but if the Malad, I cannot be Malad, and your losses, kindly take note of that. Malad, because of this, Malad, I have also put in 37 years. This is not for the first time I'm looking at the order like this. Because I can't Malad, take your losses to the earlier orders of several courts. That when a matter is not urgent, it is taken up on the board. Determination of another honorable judge.
Mr. Shan.
My lord, kindly, my lord, we are suffering. We are being,
Mr. Shan.
my lord, we are suffering. As a professional man, we are suffering. This must be your loss. Somehow to be brought it to your lordship's knowledge. And then matter on the first day made it hard in part. Now my junior has been rebuked. My lord, can I, my lord, go to that court and make my submissions? Would your lordships feel that? Kindly visualize the situation. If I am rebuked on the very first day by your lordships, and the second day I suffered an order, and the second day I am to go before that court and make my submissions. I'm not talking my question about my learned junior.
There was there,
So there he was forced to go, and that's why the hard in part But kindly see the notice of the Honorable Chief Justice. This is following the judgment of the Supreme Court. This notice was issued. Now, 9th, the regular determination the Honorable Judge sat that the matter is kept before another Honorable Judge. This was a determination for 14 days.
No, it was previously with Justice Chandra.
No, it was moved on 4th, filed on 4th, moved on 5th when Justice Chando was not available. And on 9th, Justice Chando was available.
So that is because urgent determination.
What is
was-
the urgency pleading, Mala?
That is a matter to be considered.
Kindly, Your Lordship. That's Mala, kindly take note of my submission.
We are not with you on this issue that why division bench will set aside the discretion exercise from.
Mala, where is that's Mala, the discretion must be judicious. Based on the petition's avowment, it cannot be in the blank, my lord. It's a court of records, my lord. It's a court of record. I am before the court of law. Show the urgency. All the incidents narrated before your losses at least 6, 7, 8 years back, at least not 10 to 12 years back.
Mr. Special Officer, I just have a question for you. You were looking into the inquiry report
Inquiry report.
that Mr. কোথায় গেল ওটা? আচ্ছা, did you have the occasion to appear for any of the other teachers?
I had.
So why didn't you disclose this to the learned single judge?
Look, my clients did not have any objection.
Forget about your clients. You are an officer of this court.
Look,
We trust faith upon you.
kindly-
Was it not your duty to tell to the learned judge that I have appeared for the persons in the
That
appeal?
order was placed. That order was placed.
So do you think that the judge has considered that paragraph?
No, no, my lord, the order was placed.
Forget about it. Why it was incumbent upon you to tell the judge that, my lord, I was there in a similar matter appearing for the appellants in that matter.
Lord, we kindly appreciate.
And who is Mr. Vivekananda Bose? You are Mr. Bose, yes? You appeared for those teachers, and you are now appearing for the student,
Lord-
espousing their cause.
Milord appeared for teachers.
Bulbul Sarkar and another.
Yes.
Huh?
Milord, Mr. Bhattacharya, there is no conflict. They had also appeared for college. Now they are defending the student Goenka.
If this is the point, my lord.
There is no conflict on my part. It is there supposedly on their part. With deepest of respect.
Is it
Yes,
so?
my lord.
This order, my lord,
Yes, my lord.
will not
My lord, there is no, my lord will kindly consider this. When I appear for 2 teachers against the persons who are respondent in this writ petition,
No, we are only asking you that whether this was brought to the notice of the.
May I say this? Not the order on,
You are retaliating on the basis of
No,
a
no, no, no.
question made by a judge.
no.
Huh?
My lord,
you
please
don't
Take it up. Do this, do that.
kindly, don't do
We
it.
have put a question to you. You are challenging our
No,
discussion.
No, I am tendering apology on his behalf.
Turn down your voice.
My lord, I am tendering apology on his behalf. My lord, may I answer your lordship?
Tendering of apology does not wipe away your previous activities.
100%.
I have questioned. I have put a question. to you.
100%. Your lordship has every right to put
You are
questions.
justifying. Have I asked for
Please,
your
Yes,
justification?
please.
I have asked whether Mr. Bose, you did appear or not. Did I say that why did you appear?
Oh.
You cannot appear here. Did I say?
My lord, kind. My lord, I am, my lord,
Unfortunately,
it is my mistake. My lord, kind. My lord, may I
it was
just,
rightly said by Mr. Mitro that he said that he is not a student of this era.
my lord, may I answer your lordship? My lord, kindly.
A special officer is being appointed and the special officer does not tell to the judge that, my lord, I was involved in this matter, though I was appearing for the appeal. I just cannot, I don't know whether Mr. Mitro and other.
My lord, those persons,
Lord, will allow me to reply once. Lord, give me enough. I will reply, my lord, I have the reply ready.
I asked you that did you point it out to the honorable judge?
Admittedly,
Bas,
no,
that is
but,
the query.
But my lord, there is something which we not wish to consider at this point. It is immensely important, we not consider. Please.
Just tell us what is the point?
You know, the first point is, so far as the my clients are concerned now, and my clients are concerned there. You know, that point of time, 2 teachers who had appeared, you know, they have retired from. Now they are no more teachers of the college. They have retired. Their rights are relinquished. They are no more a beneficiary of anything as of today.
and they are not even vying for anything.
They are not before the courts also, Miller. This is one. Second, Miller, The client, my lord, I am representing now, my lord, I was.
Mr. Nag,
2 minutes.
Mr. Nag, wait. You are first an officer of this court.
Lord, absolutely, my lord.
You have a separate dignity as an officer.
Absolutely, my lord.
So the expectation level goes high that I am speaking with a learned advocate.
Lord,
I am speaking with a learned advocate. I am appointing him as a special officer. Leave it to the discretion of the judge. You should be open. You should be. Is it not desirable, Mr. Nag?
Absolutely.
Today, suppose.
I bow down to this. But, my lord, I want to submit on this point 2 things which should be brought to the knowledge of the court, my lord. It is imperatively important. My lord will kindly consider these 2 orders. And thereafter, my lord, I will place a chart also, my lord, which is required. Lord, this order is passed on the 14th of September 2023, my lord, where, my lord, this is the repetition, my lord, where Dr. Ochinakundu came up and said that I want to have a voluntary retirement. My lord, kindly see the submission of the college, kindly see who is represented by the college.
I think, Mr. Nag, you have not appreciated our question too.
Now this.
No.
For what? We are not seeking a justification from you.
But I am not giving a justification as well.
This is what you are trying to
But
give.
I started on this very starting, my lord, that what Mr. Banerjee had submitted. I wanted to give a reply to that because it is important to consider, my lord, the whatever presentation was, why the special officer was needed, my lord. I do not say that I be appointed special officer. Let Mr. Shandal be appointed special officer. There is no difficulty.
Kindly
Why the special officer was needed? The special officer was needed, my lord, so that the facts of the college is brought before the courts. My lord, what was happening at that particular point, my lord? The particular point was that the records of the college, the instructions of the college was not coming before the court. My lord, the officer who was in charge of the records, who was in charge of instructing the advocates, my lord, I do not say that any of the advocates was appearing and misguiding the court, my lord. That is not the point. The point is, my lord, that the person who was instructing the advocates was instructing, hindering the justice. The records were not being brought before the courts. My lord, as on today, despite the order of the single judge, the college principal's office has not been opened. My lord, the reason is, the moment it is opened, the records, the last record which is there, that can be brought before them. That is the difficulty. And my lord, Mr. Shandal has suddenly, in a very subtle manner, not an allegation.
So who appeared for the governing body? Anybody appeared on behalf of the college on 5th?
On the 5th, my lord, yes. It appears from the order sheet, my lord, that 25th, my lord, here, my lord, unfortunately, in the array of parties, my lord, Jogesh Chandra Chaudhuri Law College is not there. Jogesh Chandra Chaudhuri College. Just give me a moment. And just give me a moment. Yes, it is a party. 17.
Yes, my lord. That is what I'm saying. And on that day, suddenly somebody else went and appeared on behalf of the state.
Jogesh Chandra Law Chaudhuri
Ache.
16.
Yes.
Now, my lord, apparently in the order passed, my lord, which has been carried in appeal, 5th October 2023 order, my lord, I am not blaming anything. My lord, I am just making this statement. My lord, I do not know. It appears that Mr. Mukherjee had the occasion to represent Sunanda Goenka.
All three.
And my lord, respondent number 28 is Jogesh Chandra Chaudhuri College, not the law college. And 29, President Governing Body, Jogesh Chandra Chaudhuri College. My lord, again, my lord, not law college. Kindly, my lord. My lord, I do not know. It is recorded 25, 28, and 29. Apparently, my lord, respondent numbers 28 and 29 is Jogesh Chandra Chaudhuri College and the President Governing Body, Jogesh Chandra Chaudhuri College. Whereas, my lord, Jogesh Chandra Chaudhuri Law College is in the array of parties is 16 and the president thereof is 17.
So what do you want to say?
My lord, Mr. Mukherjee, I do not,
Misincorporation.
I think he was only, my lord, because since, my lord, I am telling you, lordship, lest there be no confusion, since, my lord, he was referred to the bar council and everything, my lord, I also, my lord, as a mark of solidarity with him, my lord, appeared for him, my lord, in the division bench. I also appeared, my lord, there is no doubt about it, my lord, representing him so as to espouse, my lord, that portion of the cause, my lord, that so that there is no confusion anywhere. Because, my lord, there was no conflict. The advocate was, my lord, and, my lord, only one humble thing, my lord, since it has cropped up, my lord, I am indicating to your lordship, my lord, maybe it was knowingly done, unknowingly done, but my instruction is, my lord, the order of the Honorable Division Bench, my lord, of Justice Tiwari, my lord, was definitely, my lord, produced on the 5th before the Honorable Single Judge. Yes, your lordship is correct. Maybe his attention was not drawn to the named advocates. I do not know. I do not know. Oh, he drew the attention, he says. He drew the attention.
Honorable Single Judge's order also. I said that I was appearing.
Yes. Now, my lord, those two persons, my lord, apparently had questioned their, my lord, coming in the pay package.
Mr. Bhattacharya, I think
Correct.
you have not read our question. Our only question was, as a court, we have asked our officers
Yes.
that were you there in that matter or not?
Yes.
To that,
All of us were there.
To that, Mr. Bose's reply was that I had placed. He is now saying I have placed that order. It was known to the learned. That is, and his argument is that there are reasons why I was appointed as the special. So finished. We got your justification.
But I am not making any submission so far as the
Apology, Chair.
college which speaks of the
No,
advocate
apology.
on record representing the college in other matters where Dr. Ochina Kundu has challenged the inquiry committee and all that. But it appears that the advocate on record of the college now is the advocate on record of Dr. Goenka in person. So, my lord, the college needs to rechange the governing body's resolutions so far as the advocate on record of the college is concerned. Because the advocate on record, who
is the advocate?
Miss Falguni Jana, my lord, it appears.
He did not appear.
No,
she was appearing. My lord, Dr. Goenka had not challenged any of the proceedings. Dr. Ochina Kundu had challenged some of the proceedings, my lord, in the writ, thereafter in the appeal, and thereafter in VRS. Ms. Jana was the advocate on record, my lord, for the college, representing the college for against Dr. Ochina Kundu in the matter of the VRS and in the matter of the illegal appointment, the inquiry. Now, my lord, as of now, Ms. Jana is appearing for Dr. Sunanda Goenka in person. And Mr. Mukherjee, my lord, is leading Ms. Jana, my lord. Mr. Mukherjee was leading Ms. Jana in all other matters also. So, my lord, what has transpired from the records of the college is now the college needs to appoint fresh advocates, my lord, so that the point of the college can be placed, the records of the college can be placed before the court.
Yes, go.
I'm seeking your lordship's kind leave, my lord. Kindly, my lord, excuse us, my lord, if there has been any, my lord, wrongdoing, my lord. Great.
The present writ petition has been preferred, challenging an order dated 5th of October 2023, passed in a writ petition being WPA 24026 of 2023. Records reveal that ওই অর্ডারটা কোথায় দিয়েছো জয়ন্ত? রাখো তো, এটা ব্যানার্জি বলে লিখে রাখো, মিস্টার ব্যানার্জি। Records reveal that each petition was preferred by a student pursuing a LLB course at Jogesh Chandra Choudhury Law College. In short, the said college. Literally are praying for revocation of the recommendation of the appointment issued in favor of Dr. Sunanda Goenka, principal of the said college. Stop. The writ petition was affirmed on 4th October 2023 and by an order dated the learned single judge remove the appellant from the post of principal of the said college, as she was not having the requisite qualification for the post of a teacher in a college recognized by University Grant Commission, bracket A, in short UGC. Stop. By the said order, stop. The appellant was also restrained from entering into the college premises on and from 6th of October 2023 until further. Stop. By the said order, Mr. Orko Kumar Nag, learned advocate, was appointed as a special officer for a period of 3 months and was directed to visit the college and to put lock and key on the door of the appellant's chamber. On the door of the chamber of the principal's office. Stop. Next paragraph. In the said order, the court also observed that Mr. Saurabh Kumar Mukherjee the learned advocate appearing for the respondent, learned advocate appearing for the appellant hearing and others had refused to assist the court and referred the matter to be placed before the Bar Council of West Bengal for taking steps for professional misconduct. Stop. Agreed by the said order, Mr. Mukherjee, you preferred the appeal, na? Agreed by the said order, Mr. Mukherjee agreed by the said direction. An appeal was preferred by Mr. Saurabh Kumar Mukherjee and the same was disposed of by a coordinate bench of this court on 6th October 2023, setting aside the reference to the Bar Council of West Bengal for initiation of action
But it's paragraph 6 and
for initiation of action against Mr. Mukherjee for professional misconduct. Upon observing inter alia that quote unquote দেবে quote unquote marked out part of para 3 start হচ্ছে the law. The law does not permit any court to decide a matter on the basis of a telephonic conversation between the court and any of the respondents, and that observing inter alia বলে ওইটা quote unquote দেবে and that বলে same পেজের in marked out portion paragraph 6 we do not find any tearing hurry to proceed with the matter, and the learned advocate ought to have been given a day's accommodation to obtain necessary instruction. Stop. Mr. Shanna, learned advocate, তুমি পাবে কি করে 6th October appeal, এই যে appeal mark করে দিয়েছি। Mr. Shanna, learned advocate, appearing for the appellant submits that the learned single judge that on 5th October 2023 the learned single judge adopted an unusual procedure. Stop. The court called the appellant stop. Unusual procedure. Stop. From the courtroom, the appellant received a phone call from an unknown mobile number. Stop. The caller identified himself as Mr. Vivekananda Bose, a learned advocate, who was calling the appellant under the instruction of the Honorable Single Judge. Stop. Over the telephone, the learned single judge inquired through the said advocate as to whether the appellant was a national eligibility test as admitted that over the telephone and on the inquiry made by the learned single judge. It was submitted by the appellant that she did not qualify any national eligibility test bracket A in short net and state eligibility test bracket A in short slate. Stop. However, no, no. Anyway, please continue. Last like typical. Stop. It was also submitted that she was actually appointed in 1998 when the college was a private college and she was in a pay package scheme, and therefore she continued with her appointment in the post of principal. স্ট্রিমটা বন্ধ করে দাও। affidavit, they are paying for the affidavit. Letter for purchase also. So that on the basis of ossification.
Yes, my lord.
Granted.
Yes, ossification test, my lord. This honorable court, my lord, directed for the second ossification test, so
That
they
is
are by negating. That was not done. They have only reviewed the first one. They have not done. On the last occasion also, your lordship was pleased to observe, my lord. Yes, that was not done.
What was the reach court order?
20, my lord, impugned order, my lord, kindly see the order of 25th of April 2023. The penultimate paragraph, my lord. Page 6 of that order.
You denied the relief.
I denied the relief, my lord. Thereafter, the relief was granted. What was the relief that MMCCB granted? From after doing the ossification test, MMCCB granted from the date of death, whatever it is, my lord. So thereafter, my lord,
Preferred appeal.
yes, I preferred appeal. Writ petition, after the writ petition, my lord, ossification test was done. Thereafter, I preferred an appeal, my lord. Now, my lord, my contention that the ossification test was not run properly, my lord. There was a huge difference of age. 1 week after vacation, my lord.
My lord, may I suggest one thing, my lord? I have talked to my client. Your lordships may direct, my lord, my client for, my lord, to be, my lord, re-examined.
No, my lord. Here I am, my lord.
Because already order is there.
Not
Now, my lord, if
Now,
my
my lord,
landlord
I have,
objects, then that
let him come. My lord, 1 week after, my lord.
First December.
1st December. Grateful, my lord.
and my lord, in the meantime, amount due may kindly, my
No
lord,
amount
state.
is due, my lord. No amount is due. Let him show what amount is due.
Yes.
That was not the order.
My lord, I am for the petitioner. I am for the petitioner.
And we are for the respondent, but my senior is busy in another court. Huh?
Which respondent?
Sanjay Kole.
Sanjay Kole.
Sanjay Kole.
I am for 5 and 6.
And Sanjay Kole, my senior is busy in another court, is arguing there.
Sir,
So-
সঞ্জয় কোলে কত নম্বর রেসপন্ডেন্ট বলুন?
It may be,
To talk with Mr. Ali and settle. This matter, it has come up for hearing. You are appearing for which respondent?
Sanjay Kole.
কত নম্বর?
Sanjay Kole is the council.
Well, he is number 1. Sanjay Kole is number 1. And I am for 5 and 6. 5 and 6 I am.
If after 2 p.m. It can be heard.
He spoke for you, any scope for Mr. Bhattacharya. What is the matter?
Well, the matter is the recruitment process. The recruitment process, the petitioner could not succeed. The criteria was there,
Sanjay Kole was the applicant.
applicant.
He preferred an original application.
Yes,
Praying for what? Challenging a selection.
yes, challenging the selection because he was out of the panel. His name did not figured in the panel. It was,
Now, who are the respondent numbers 5 and 6?
no, Mr. Ali is appearing for respondent
No,
5 and
that-
6.
Who are they? They were participants.
Yes, and they are successful candidates.
That?
They are successful candidates.
Oh, they are successful.
Thank you. Thank you.
তাই তো মনে হচ্ছে।
Now, what did the tribunal say?
Tribunal, my lord, completely misdirected itself while passing this order. My lord, I am before your lordship enters into the matter, I shall
I shall request pray before your lordship to come to page 20.
No, we are asking Mr. Bhattacharya, is there any scope for any interim order?
No.
There is no scope.
No.
So we have to hear it finally. Have you annexed all the pleadings in your
Yes,
petition?
yes. No, not this petition only. There should be supplementary affidavit. My lord, I do not know whether those are.
Supplementary evidence.
I have filed. I already have filed.
Then
একটু রেকর্ডটা দেখে দিন
yes, supplementary evidence. So you have brought on record the
document records which
and rejoinder.
yes.
So all the documents which were relied before the tribunal
Yes.
and before us.
Yes.
So we fix up a date for final hearing. There is no scope for issuance of any interim order.
My lord, your lordship will kindly come to the judgment. I mean, the final order of the tribunal, which appears at page 15. That is the last page of your lordship's will.
Yes.
The last page. The last page. Your lordship says?
Yes.
Yes. In view of the aberration from established procedure, as noted above, the authorities are directed to recast the panel strictly in terms of para 219, so and so, as enumerated supra within 3 months from the date of receipt of a copy of this order. That means, my lord, the selection list that was made, in which we actually were the successful candidates, that has virtually been given a final say that you recast the panel. That means our selection goes.
You were there in the panel.
Yes, my lord, your lordship will kindly come to your lordship read
You have not preferred any appeal.
at page 16. Your
You
lordship,
have not challenged this order.
my lord, we did not because they themselves, it is the government, they themselves prefer an appeal against the order and making ourselves as the party. Therefore, we have our opportunity to make our submissions before your lordship. Lordship will kindly come, my lord. It will be very clear. Lordship will kindly come to P2 at page 50.
15.
At page 15 of your lordship's whip. Page 15 of your lordship's whip. This is annexure P2. Selection for the post of junior engineer under TRS EMU department on level 6, GP rupees 4,200 against 25% promotional quota. So this was a circular made, and in the apartment, according to this circular, we participated. It is said that the respondent number 1 also did participate pursuant to this notification. Now the question is, in this circular, your lordship will kindly go to the last paragraph. This may please be published widely amongst the technical assistant of TRS MU department, Howrah, so that all technical assistants of TRS MU, Howrah division can be well aware of the above notification. So it is a divisional recruitment, not a general recruitment. Now your lordship kindly goes the next page. In the next page.
My lord, I am keeping silent because Mr. Ali has taken charge of it.
I have taken charge of my brief, no doubt.
No, then Mr. Ali, I should inform in your line.
No, there.
No, in your line.
There.
Don't oppose it.
So my lordship kindly goes to next page, page 16. Page 16, these are the provisional select list against 25% quota. Based on overall performance, the following candidates who are recommended in order of seniority by selection committee and being free of DAR vigilance clearance are hereby placed in the panel provisionally for the post of junior engineer. Your lordship will kindly mark seniority by the selection committee. Now, this is a selection that is to be made on the basis of seniority, not on merit. So it is on seniority that is to be placed, and that too limited to Howrah division. My lord, your lordship kindly sees 4 and 5. Shantanu Gangopadhyay and Swapon Ghosh. Before your lordship, they are the respondent number 5 and 6. So these two persons were actually selected on the basis of their seniority for the purpose of junior recruitment, junior engineer in the Howrah division at 25% quota. Now this selection list was under challenge by the person, my lord, that's Sanjay Kole, respondent number 1. Now respondent number 1, his claim is that he is also entitled, but he didn't belong to the Howrah division. Had it been a general recruitment, the rule had been otherwise. But in so far as it is Howrah division, because limited to the vacancy that arose with regard to the Howrah division only, there the selection goes. And in that, my lord, the selection process is, my lord, your lordship will kindly goes to the selection process. It is according to the recommendation of the 6th Pay Commission as to how the selection will be made. At page 32, Annexure P5. Annexure P5. At page 32, Annexure P5. Lordship kindly goes to the C. Not A, not B, not only C. For A and B above, in case of 2008 and 9 for all candidates in the zone of condition are not available, ACRs up to 2007-8 may be taken into account. You also have seen that. And what about A? A is post carrying on the grade of rupees 4,200 proposed to be filled up by seniority cum suitability or suitability with prescribed benchmark as indicated in the statement may be filled up with the benchmark of 6 marks out of 16 marks in last 3 years ACRs, duly considering the existing instructions for promotion based on confidential report. Now, in our case, my respectful submission, my lord, it was the seniority that has to be counted, which your lordship will kindly find.
Now, what did the tribunal say?
Pardon, my lord?
What did the tribunal say?
The tribunal said no. The tribunal considered it as if it is a general selection. As if it is a general selection. My lord, it is totally misguided, my lord. With due respect, my lord, a misguided tribunal has come to the conclusion that seniority rule will not apply. It will be the seniority and merit. It is not that. Lordship will kindly seize that. Because it is with regard to this one, and the basis I have said, my lord. Yes. My lord kindly goes to page 36. There it is quite clear. Page 36. Lordship says junior engineer GP 4,200. Our case is junior engineer 4,200. GP 4,200. 15% so and so, general selection. This is general selection. Guided by paragraph 141, 1 EBM so and so, all this.
You are presently holding the post of
Junior engineer. It is junior engineer in the grade your lordship has found, my lord, at page.
Promotion on the basis of seniority to the post of junior engineer restricted to the Howrah district.
Yes, only we get to Howrah district.
Now, presently, which post are you holding?
No, it is the very same post, but the learned tribunal thought that it is not regarding a particular division. but it is with regard to the general selection. That means all over the Eastern Railway. Lordship, that is the whole problem.
Three types of promotion system is there. One is 25.
Mr. Ali, as the records have come, we fix a date for hearing in the presence of Mr.
As your Lordship pleases. But my lord, my problem is, because of this reference to the department for recasting the panel, my lord, juniors are being promoted. To our juniors, they are being promoted, and we remain stagnant.
Had Mr. Bhattacharya learned that for Chanar and Mr. Ali learned senior counsel on behalf of the respondent numbers 5 and 6. Today, an adjournment half of the respondent number
1.
Respondent number 1. The last opportunity to respondent to appear. Matter stands at stop. We have been informed that all the documents upon which reliance was placed before the learned tribunal have already been annexed to the petition and the supplementary evidence filed by the petition. Thereof, the matter is ready for hearing, and accordingly, we seated in the supplementary of this court on 29th November 2020.
For orders on November
18th
November 29, as your Lordship please.
And please inform your counsel that if he doesn't appear, we have to proceed upon hearing. We will not give any part.
Inform করে দেবেন 29 November for orders থাকে।
29th.
Lordship kind.
দেখি আপনারা আছে বড় বড় একটা আসছে
But 16 and 17, the issue is identical in both the matters. A decategorization and alternative employment. That is the issue involved in the both the writ petitions. So now this is the affidavit of service, although they are appearing 16 and 17 2 years. Sleep. Well, here the
Both the matters are against same judgment or separate matters.
separate judgments, but the issue is same.
Oh, I see.
In both the matters, the identical judgments have been passed, but since two matters were filed, so separate judgments have also been passed in both the matters.
Mr. Bajpai, please give us 5 minutes. We go.
My lord, my lord.
Order under challenge is 22nd November 2020.
My lord. Their number. Item 16. now দেখাতে
So Vajpayee, what is pay protection after degradation?
My lord, the question is, my lord, while making decategorization, I cannot much add in reverse to the statement of the to the judgment. But the question is, my lord, while considering the case of the petitioner after decategorization, my lord, the authority has written that
Is that order, Mr. Vajpayee?
my lord, the question, the application is not happily drafted because the application filed before the honorable tribunal has not been annexed with the original writ application. So I have got the copy, but my lord, friend is since junior, my lord, he has taken paid for leave to produce the same at the time of hearing. So if your lordship so directs, my lord, so we can file a supplementary affidavit annexing the copy of the application filed before the tribunal. Because on the initial day at the admission stage, my lord, without asking for reply, the matter has been disposed of. So, my lord, if your lordship,
You have the copy, Mr.
yes, yes, I have got 2 copies, so that is the
I have
problem.
got another two.
So the
You did not, it was disposed of on the first day.
first date. So at the admission stage, and my lord, the without asking any reply. My lord, the question is, my lord, while considering the screening committee, while considering the
Yes,
case of the
you was a copy. You have 2 copies.
Yes, ma'am.
Where is that?
serial number 2 is the item number 16, Tapan Kumar Machi. My lord, these
Where is
remark
that order of 31st August 2022, which was challenged in the tribunal.
in the tribe.
31st August.
Yes, that is the observation.
Page number 14 of the original application that I
Yes.
handed up to you. Lordship.
Page number 14. My lord, serial number 2. Remarks column, lordship, kindly come.
Tapan Kumar.
My lord.
Alternative weapon.
Yes.
The order of
Screening committee.
31st August.
But there is another order subsequent to that. That was also challenged. Page number 19. That is the
What
last
is the
order.
date of this page 14?
14 is 30th of August.
Where do we find it? First of all,
That has been appropriately
Signed.
not xeroxed. But in the signature, your lordship will find 31st of August.
But subsequent another order is there. That is 19. That is also challenged.
Yes. That is the regret letter.
amendment was brought in. What was the amendment? Page 19.
Page 19, my lord. My lord, 19, my lord, is the representation that I made. And after that, my lord, your lordship will find page number 19. Your lordship is the order which is passed after the representation was considered. That was challenged.
This is what date?
This is my lord, 30th of September
2022.
2022.
Not legible also.
Not readable. Yes, 30th of September up to this it is readable. 20
30th September, if your lordship sees 19.
uh,
This was not the order under challenge.
This was what the order under challenge as well.
Your period was not there.
But I tell your lordship,
was
my lord,
not
it is there.
The 35 weeks.
this was not challenged.
What was
Yes.
the decision communication?
My lord, this is the communication, this is the decision, this is the reasons that they have given. 19. This is,
The reason.
my lord, that is the ground on which well that was set aside.
So Mr. Vajpayee, ground is well settled that.
Yes.
Yes, my lord, that's why, my lord, I submitted before your lordship that much I cannot add in refers to the judgment. But the question is, my lord, as on date, my lord, the suitable alternative post is not available and number of candidates are there. So how many supernumerary posts will be created? And that's why, my lord, they have been offered with pay protection in the alternative post, along with request that search is going on by the search committee. As and when the same will be available, you will be shifted back to there. And if you agree to this proposal, then only we can provide you this employment in one step below. My lord, the question is, my lord, he did not agree from since 2022.
He
So,
did not
agree.
Yeah.
So, my lord, their case is that
He has not joined the post.
no.
No, man, I did not.
And after join,
First of all, my lord, because since my learned senior is taking my lord all the matters together, my lord, in one of the posts where my lord I have been declared that my hand is not working, it's not operable, my lord, I am my lord given employment as a carpenter. So my lord, that is completely in violation of the rule, my lord, that is provided by the
No, no.
respondent railways, which says that it has to fit
no,
in
this
the
is,
separate
Let's
alternative
go
category.
one by one.
Yes, my lord,
Yes.
kindly do that.
This one first.
Lordship.
What is the order of the tribunal? That they will find out an alternative.
Yes.
post in Kumar.
Yes,
And till such time, alternative appointments are made.
yes,
yes.
that
As per provision, the applicant should not be deprived of their rightful
My-
entitlement.
Lord,
What
this
is their rightful entitlement?
The rightful employment is keeping me in the supernumerary post.
how it is
But that
possible?
is on the, or that is on the rule of the railways. If I can take your lordship to the rule
What
once.
is this 8999?
Yes, if I can take your lordship, lordship has got the original application in your hand. My lordship, if I can beseech your lordship, my lord, kindly takes up page number 22. It starts from 22.
Page 22 of-
My lord, of the original application. My lord.
Yes.
My lord, if I can take your lordship directly, my lord, to 1303 at the bottom of the page. Has your lordship got that? My lord? Or may I will place one?
Right.
Yes.
In a supernumerary post.
Yes.
Thereafter, my lord, yes,
They are not, you have,
I was. And I was thereafter certainly, my lord, they say that since I am not finding out, basically when they are not making any effort, be that as it may, since I am not finding out, you go and join in a lower category post, in a post which is having lower grade pay.
But
do
with
that.
all pay protection.
Now, that is the problem my lord, I am been facing, because this has been the specific mandate of the particular circular of the railway board as well as section 47 of the Person with Disabilities Act, lordship says.
No, but
8999.
yes.
My lord, this one is my lord 8999, my lord.
So this one is 8.
Yes, my lord, if I can take your lordship, page number 20, my lord,
Then why does the tribunal say that still alternative appointment is given in a
Yes.
supernumerary post? You will not be deprived of your rightful entitlement. What is the meaning of
my lord, the meaning before your lordship subject to correction is that since,
provisions of
I'm sorry, I'm sorry,
And 1304
my lord,
is the answer to your lordship.
page number 22 is 89 by 99, which as the lordship has seen. This is the revised edition 1989. At the top of the page it is written. So my lord, 1303 is the provision, my lord, is for the persons who have been, my lord, medically decategorized. So if a person is medically decategorized as alternative suitable, post has to be given, and plus with the similar pay protection, pay benefits, the benefits with the similar pay scale of pay. If it could not be found, then you will be placed in the supernumerary post. Till such time, until and unless a specific suitable with similar pay scale post is found. So, my lord, this is a mandate under the Person with Disabilities Act by, if I can take your lordship to pay.
We understand.
I'm sorry.
What did the tribunal mean to say? That to create
Yes.
an employment may be searched out and offered.
Yes.
within 2 months. And next paragraph is should not be deprived of the rightful entitlements. This becomes vague, no?
My lord, I tell your lordship, the rightful entitlement that I am right now,
Tribunal ought to have spoken that keep him in the supernumerary post.
my lord, since the learned tribunal, my lord, said my rightful entitlement is the supernumerary post.
Where is it?
My lord, because it is the law. This is what, my lord, the learned tribunal said.
Why will the tribunal?
Because, my lord, if your lordship, my lord, sees the entire order of the learned tribunal, this 1303, my lord, is quoted. My lord, and it is written that until and unless you find a if your lordship only go through this judgment, lordship has already seen. So there your lordship will see that 1303 is quoted in the tribunal's order, which your lordship will find at page number 4, internal page number 4 of the learned tribunal's order. There your lordship will see, having regard to RB 8999, which your lordship has already seen.
Where is 1303?
I'm sorry, ma'am.
1303.
Yes.
That has been quoted.
Quoted. So, my lord, pursuant to this only, the learned tribunal, my lord, has come to the conclusion that this is the rightful benefit of this particular.
Where is that, sir? We are searching for that.
My lord, it is quoted. After that, lordship sees after what is written in paragraph number 7, it is with respect to the subsequent order which your lordship has seen, which is devoid of merit. So, lordship, the learned tribunal has criticized that in paragraph number 7.
But that has
8.
not been set aside. That has not been set
Now, my lord, lordship will see that if I can place.
Dismiss the origin, dismiss this petition. How can you establish in contempt?
Because, my lord,
meaning of the order is that you have given this in supernumerary.
But subject to correction, my lord, I have already taken out an application for, my lord, implementation of this order. So, my lord, which is pending. And, my lord, lordship, if I can place, my lord, paragraph number 8 of internal page number 6 of the impugned judgment. So, my lord, it says, lordship, just above paragraph number 8, the paragraph, hence.
That is non-speaking order.
It is set aside, quashed and set aside. So, my lord, the order is quashed and set aside. The order is not there that I will not be given the alternative appointment or my representation for getting the alternative appointment. It's quashed, it is set aside. Thereafter, my lord, what does the tribunal, my lord, say? We also infer that the condition in 1301, namely the medically decategorized employees, should be shifted to the same pay and pay scale benefits, has not been adhered to its true letter and spirit by the authorities. By saying this, my lord, the learned tribunal tried to mean that since I was there in 1900 grade pay, I was, my lord, downgraded to 1800 grade pay. So this is why the learned tribunal said it is not adhered to 1301. Now, my lord, reference is also made to 1304 quoted. Such alternative employment should hence be searched out and offered to the instant applicants within period of 2 months from the date of receipt a copy of this order.
I am not denying that.
Thereafter,
Can you place page 19 of the application? Original application. What is written here? The representations of
Yes.
following medically.
yes, may I please?
Staff.
The representation of the following medically decategorized staff of security department has been received by this office. The name of applicants as under one is me before my lord. Thereafter, my lord, at the down, all the
Competent authority has regretted.
where up to the competent authority has regretted the same. So, my lord, this is the representation which I preferred, which your lordship finds, my lord, at page number 18 of the learned tribunal's brief, my lord, the original application. My lord, resultantly, my lord, I'm sorry, my lord. I'm sorry.
No, show us 1304.
Yes. If I can take your lordship, my lord, to page number
23.
23 of the original application.
Yes, what does 130?
May I, my lord, please? Has my lord got that? Yes. Disabled medically decategorized staff to be absorbed in posts they can adequately fill. In the matter of, though, my lord, I was just stressing upon this word because that may be important for the next matter. Be that as it may. In the matter of absorption of disabled medically decategorized staff in alternative posts, the railway administration should take care to ensure that the alternative employment offered is only in posts which the staff can adequately fill, and as far as possible should broadly be in allied categories where their background and experience in earlier posts could be utilized. While finding alternative posts for absorption of disabled medically decategorized staff, the railway administration should ensure that the interests of other staff in service are not adversely affected and no reversion of any officiating railway servant is made to absorb the disabled medically decategorized staff. For this purpose, attempts should be made to absorb the disabled medically decategorized railway servant not only within the unit, division or department, but in other unit, division or the department.
So the question is, my lord, the
May I,
supernumerary
please?
post is not there. The question is, these are the issues that are to be fulfilled. Yes.
So thereafter, my lord, may I take your lordship to 1305.
Not applicable.
My lord, it does. Lordship comes to 1305. Absorption, may I, my lord, please? It is, my lord, at page number 23. Absorption in post identified for employment of physically handicapped persons, creation of supernumerary post. The railway servant falling in group 1 mentioned in 1302 or those who are declared unfit even for the lowest medical category may be observed in post category identified as suitable for the employment of the physically handicapped person, and fresh recruitment to the post category upon market pay scale supernumerary post. But it is with respect to those persons who are completely incapacitated, not me.
Why do you say?
But
Falling in 1302.
yes.
1302 come.
But yes, 13021. If I can take back your lordship to page number 22. 1302 says classification of the railway servant declared medically unfit. Railway servant acquiring disability during service and declared medically unfit are divisible in two groups. One, those completely disabled for further service in any post in the railway, that is those who cannot be declared fit even in C medical category. And two, those disabled incapacitated for further service in the post they are holding but declared fit in a lower medical category and eligible for retention in the service in post corresponding to the rural medical category. So one is totally incapacitated and two is
So you come within
two. Thereafter, 03 says the railway servant both in group 1 and group 2 of 1302 above cases to perform their duties in the post, and there, my lord, itself at the last line says about this special supernumerary post in the grade in which the employees are working on a regular basis that your lordship has already seen. May I again please, my lord? 1303, that is the prime.
1304 is not 1304.
1303 is applicable to me. Lordship sees that once.
We have seen that.
Yes, absolutely.
1304 and 1305, what is your concept?
My lord, 1305 is not for me.
Why
1305 because it is, my lord, for the person who is completely incapacitated. The group 1.
Where do we find
My lord,
that?
1305, my lord, says the railway, the first line, the railway servants falling in group 1 mentioned in 1302 above.
That is
Group.
which you showed.
Totally incapacitated.
No, very good. Now, why does 1304 does not apply?
But I tell your lordship, but it is applicable in every cases to 1, 2, both of them. It is applied to me. I'm not saying it is not applicable. 1305, I said.
No, you will be placed in an allied service.
My lordship says In the matter of absorption, disabled medical incapacity in alternative post, railway administration should take care of to ensure that the alternative employment offered is only in the post which the staff can adequately fill, and as far as possible should broadly be allied categories where their background and experience in earlier post could be utilized. So I'm not saying that I will not work in the railway. All my I'm beseeching that all the service conditions, everything, same pay scales has to be protected. So my lord, what did they do? Lordship has already seen. If I can take your lordship once to their stand, that your lordship will find at page number 14 of the original application.
Yes.
My lord, if I'm sorry. With lower grade pay.
But why you are not joining there?
Because my lord,
You join without prejudice, what is your problem?
my lord, I tell you, lordship, my lord, we have seen what is the effect after joining over there. I have got the evidence to that effect. If I can take your lordship, the similar matter that has been placed, addressed by this honorable court, the division bench, where my lord, the person has joined without prejudice, said that I'll have to leave. So accordingly, he joined. Thereafter, the stand the railways took that since you have joined, no, nothing could be done. That was the order that has been passed against me.
This is
Against
hypothetical.
which I have come, yes, this is there, my lord. I'll be placing the judgment before this honorable court. Because there, this honorable court has specifically observed that you cannot compel someone to join. And similarly, my lord has said that you cannot lower the grade pay as well. So this is no more, my lord, subject to correction, res integra. If I can place your lordship, my lord, the judgment of this honorable court. May I hand up to your lordship? My lord,
My learned friend submits that the person's right hand is not.
Your lordship.
Yes, Mr. Bajpayee, what is your concern?
I'm sorry.
My lord, the question is, my lord, my learned friend submits that the right hand of the petitioner before the tribunal is not working, and he has been given the post of carpenter. But he was previously ex-constable, and his disability was due to his vision, not for physical disability. That's why he was chosen by the screening committee to be placed as carpenter for the timing. Since the alternative post is not available.
But
And
the law says that you have to give a.
yes, I cannot evade the law, my lord. The question is, my lord, that the learned tribunal has said that you join and all the benefits of the post should be given. So, my lord, last para, your lordship was pleased to read that in the order under reference, my lord, the under challenge, my lord, wherefrom it is evident that we have already done, but he preferred not to join until the post as chosen by him should be offered, even by creating a supernumerary post. But we are offering employment, we are giving you pay protection. Even after that, give us some time to screening committee to find out an alternative post. In that light, my lord, it is premature. Because, my lord, the question is that somebody was not given the benefit, so I will be deprived of the benefit. This is hypothetical submission, possibly, my lord, subject to your lordship's approval. And let him join for a certain period of time if he is aggrieved that yes, the authority has done nothing to that extent, but for his accommodation in a suitable alternative post. My lord, in that event, definitely they have grievance, because we are to give him, as per rule, the alternative post, equivalent alternative post.
That what you are arguing, Mr. Bajpayee,
Yes.
is not reflected in the impugned order.
Yes, till such time that an alternative appointments are made available.
Ordered impugned before the tribunal.
Yes.
30th September.
Yes.
Wherein you said that your supernumerary post entitlement is regretted.
No, my lord. He is saying that in carpenter post, lordship, kindly see the representation of the petitioner. Yes, I am submitting unwillingness to.
Yes, because the representation speaks that it is a vested right that has been denied. But the question is, the question is not that. We are not denying. As per rule, he is entitled to get a post, suitable alternative post. But mm, the representation does not speak that. But, Lordship, kindly see the representation. Here's annexed one representation. The second one is not here. However, my lord, unwilling, I am submitting unwillingness to resume the duties of carpenter 2 in the second application, definitely. Therefore, it is sincerely prayed that considering my physical disease, necessary arrangements may kindly be offered to any other post. My lord, that is under process. The screening committee is actively searching for all the disabled candidates. But the question, or hand in hand, that is the problem. That my instruction is that we are going to offer them as per rule. But immediately these vacancies are available, so we are putting them with appropriate pay protection, and that is the order of the learned tribunal also.
Yes, we are not altering that.
Yes.
It's been established in the application for implementation that the
Yes.
entitlement is pertaining to the lower post in which he has been placed with pay protection.
Yes.
Then their
That is that we have given them. We have given them.
Take that point in implementation. Then why you are coming up against this order?
My lord, since they are not joining the post, and this order we have challenged, my lord, because of the fact that
Your circular does not say that
yes,
they must
yes,
join.
yes.
There is no compulsion.
No, not at all. Not at all. That I must agree, my lord. But the question is, my lord, only the supernumerary part is our grievance. Nothing more, nothing less.
The present application has been referred. Challenging an order dated. November 20.
Interruption. Before Lordship passes the order, there are two original applicant in this original applications. One is Topon and another, my lord, is
From North, right?
no.
Second matter. Second matter. Yes.
My lord, another, my lord, is at serial number 42 of the combined month list.
Oh, Prono. Yes.
Then what is the other matter?
That is a single person, single petitioner. The second one. So there are two original applicants or applications. One original application, my lord, contain two petitioner, and
Which one is that?
the first
That
one,
is
which
the
is Lordship
first
is
one.
dealing.
First
Serial
one,
number 16.
don't find the names of the applicant.
But the writ petition, Lordship says the order. If I can take your Lordship to the order, because the order impugned.
Order impugned says that two original applications were taken.
Yes.
Yes.
One is of Topon, other is of Prono.
Pranab, yes, I'm talking about Pranab. Pranab is pending, my lord, at serial number 42.
And which is the next one in the list?
That is a second original applicant with respect to separate original application.
That is 17. Serial number 17. Today's list.
Fact is the same.
Fact is the same.
Identical order pass.
Identical order.
My lord, yes. Internal page 1 of the impugned order, Lordship.
So where you are placing this judgment, what you wanted to show?
Yes.
Where is that line that having joined?
Yes, my lord, that is the case itself. If your Lordship see the facts on the first page, that I initially, my lord, joined and said that I am agreeable to join, and after that they issued the office order, which has been challenged before the learned tribunal. The office order said that since we have joined, so no further.
Where is that?
Well, that is what is challenged.
Reference?
Yes, but at the first page of the
Yes.
judgment, Lordship. The instant writ petition has been taken out challenging such and such order of the learned tribunal was dismissed on the ground that the petitioner himself opted. Lordship has seen the last 3 lines of the first paragraph. The petitioner himself opted for lower post at the lower grade pay. Therefore, he is stopped from contending otherwise. So this is was challenged.
Then what did the High Court
Yes.
say?
All right. If I can take your Lordship to page number internal page number 5. the observations, the everything is there, and also 1304.
11.4.
Yes. Precise, it is, your lordship will see internal page number 5, the last but one paragraph which starts with precisely.
Page?
Internal page 5. The paragraph 1301 which your lordship has seen is quoted. It is continuing on the next page.
আমাদের হাইকোর্টে জাজমেন্ট ঠিক আছে।
The present repetition has been taken. An order to take
42 এই ওটা 42 monthly list না 42 তো আসল কাজটা করবো তো
asking.
ছেলে পেলে একটু দেবে একটা
So this is Tapan Kumar Maji. Pronouns swear. 42.
42. Yes.
Pronouns matter is
42 of the combined month list.
Preferred an original application /350/01756/2000.
item of 42 as on
One of unnecessary details. That while the petitioner was while the applicant respondent was working as a constable in railway protection sent for medical examination. Whereupon it was diagnosed that he was suffering from quote-unquote a CSR macular scar. And it was opined that his visual condition is not fit for his present job as constable. According respondent was recommended for appointment to the lower grade post in housekeeping assistant in medical department in grade pay of rupees 18,000 with all pay protection. আর constable বলেছো না ওই working the grade pay of rupees 2,000 which was further enhanced to 2,000. Aggrieved by such petition, agreed thereby, the respondent submitted a representation stating inter alia that he cannot be placed in a lower post at a lower grade pay. Lower grade pay. As he cannot be placed. Comma. And was unwilling to join the post of housekeeping assistant. And he should be given the benefits of, and he should be given the rightful entitlements in terms of Era 1302. 1302 of the Indian Railway Establishment Manual Volume 1. Yes, Mr. Roy, that was your guess.
My lord, yes.
Have you heard?
Not partly, my lord, yes.
That you expressed your unwillingness since it was a lower grade post, and as in terms of this IREM manual 1304, the entitlements, and you are entitled to the
Supernumerary post.
rightful entitlements in terms of
130.
1304. 1303.
Sorry, my lord. 3. I'm sorry. Yes. Yes, I'm sorry, my lord. 303. I'm sorry. Yes.
Such representation was, however, such prayer was, however, regretted by a memo dated 30th of September 2020. Challenging the memo dated 31st August 2022 and the memo dated 30th September 2020. Respondent approached the learned tribunal approached the learned tribunal. Mr. Vajpayee learned advocate appearing for the petitioner submits that the learned tribunal did not adjudicate the dispute in its proper perspective. The petitioner in view of his disability was offered the post of housekeeping assistant in the grade pay of 1800 with all pay protections as per admissible.
Only the post differs.
The
Submit that the learned tribunal did not adjudicate the dispute in its proper perspective of the petitioners in view of their disability.
in view of the proper perspective.
the petitioners in view of their disability.
Applicants to respondent of his disability.
Was offered the
Such and
post of house.
The said respondent, however, refused to join the said post. Such issue, refused to join the said post and approached the other. Explained from adjudicated dispute in their proper class. So the respondent was offered the post suitability, but he refused to join. Upon such refusal, he cannot turn back and claim turn back and insist that his case needs re-examination so that he can be absorbed, in a suitable vacancy equivalent to the scale of pay enjoyed by him prior to his medical visit. Such argument as advance was glossed over by the learned tribunal and no finding was returned on the said issue. Such infirmity in the order warrants interference in the present. But contra Mr. Royal Learned Advocate appearing for the respondent submits that the IREM clause 1303 itself creates a right upon the confers a right upon the respondent to be adjusted against or absorbed in a suitable alternative post. And in the event he cannot be immediately adjusted, he may be kept in a supernumerary post in the grade. Stop. The respondent cannot be in view thereof, the respondent cannot be compelled to join a lower grade post as offered by the respondents, as offered by the petitioners. He further argues placing reliance upon an unreported judgment delivered in the case of Vikas Rai versus Union of India and another. Mr. Rai argues that in the said case, the petitioner joined the lower grade post without prejudice. But for such joining, the authorities refused to place him to the appropriate grade post. Agreed thereby the dispute. Was considered by the Honorable Court, and it was internally directed that a meaningful reading of the provisions of IREM leaves no doubt that the railway surveyor, who fails his vision test and otherwise because of the disability acquired, vision test, the incumbent service should not be dispensed or reduced in rank, but he has to be shifted to some other post with the same pay scale and the service benefit, irrespective of having accepted the lower grade post without prejudice to his rights. Are the learned advocates appearing for the respective parties and consider the case only for stop. We do not find any reason to interfere with the observation of the learned tribunal that the order by which the respondents prayed for the examination was rejected was a non-speaking one, and the same has accordingly been rightly set aside. A composite perusal of the provisions of the IRDM as placed before us by the respective parties. It appears that a person suffering disability cannot be placed in a post in a lower grade post. It is an obligation on the part of the authorities to place him in a, not to downgrade him, and to adjust and absorb him in suitable alternative posts. The provisions further detail that in the event such post is not available, the incumbent should be kept on a special supernumerary post in the grade in which the concerned employee was working on regular basis before being declared medical transfer. The denial on the part of the authorities to grant the benefits as prescribed. Stop. He said conspectus. The learned tribunal rightly directed that alternative employment should be searched out for the and should be offered to the respondent within a specified period until such time an alternative appointment, until such time, as per provisions of Article 8999, the respondent should not be deprived of his rightful entitlements. Upon considering the factual issues, the learned tribunal arrived at specific findings and did not find any error in the same. In view thereof, no interference is called for in the present petition. More so when the same has been preferred about 5 months after the tribunal disposed of the original application, and there is also no explanation as the petition being such and such is accordingly dismissed. However, the next matter, same matter. Are the second one also same?
But yes, same. A little bit difference is there. But difference is that I have not been. But my grade pay was Topon is same. Topon is 42. No, I'm sorry. Topon is the matter that your lordship. Yes. And Pranab is 42. Pranab is same. The last line will be different. That will be, my lord, lordship has said that it is after 5 months they come. In Pranab, my lord, after 9 months.
But that explanation has already been given. Why?
Explanation given, Mr.
Yes. Last paragraph of the writ petition.
Without
Paragraph 19.
We have not included.
Well,
Original, where is the original application of
May I hand up to your lordship?
Yes. We have checked up, na same thing.
Only grade pays are different. I'll just address to your lordship.
Why it has not been stated in the tribunal's order?
Ought to have stated, my lord, because it is grade pay of 2000.
no, that is not stated in the order. Impugn.
The grade pays are different, my lord. Only when it was previously.
Those it has not been referred to also.
Yes. But the point is same. I tell your lordship, since it was page number 16 of the original application. Lordship.
Next.
No.
Under Somnath law. Somnath is at page 16, serial number 5.
Somnatra is
Different. A little bit different, yes. So pronouns, my lord, only difference in your my lord's. Oh, I'm sorry, my lord.
Somnath to carpenter too.
তপন এটা কি কোনো বলে একটু একটা নোট করে নাও না why same rate to 20,000.
It was 2000. The previous matter was from 2000 to I was made 1800.
24,000. 2,400.
Yes, my lord. Yes. Yes. After MSU to the 2400. Here, my lord, it is from 2000 to 1900 I was met.
Working as constable,
Yes, my lord.
working as constable.
Same, same.
প্যারাগ্রাফে এটা বলেছি 2000 enhanced to 2400 এখানে শুধু দেবে in the rate pay of rupees 2000.
সোমনাথ বলছো তো?
No, no.
তারপর where is the order of degradation housekeeping?
My lord, at page number 16, lordship has seen the, it is, my lord, Hammerman. Page number 16 or the original application.
16.
My lord, page number 16 of the original application.
That is the finding
No,
of
no.
the screening committee.
পোস্টটা হচ্ছে হ্যামারম্যান ড্যাশ
My lord.
212 in rate pay 1900.
Lordship.
ওটা আগে, হ্যাঁ, হ্যাঁ। তারপরে রিপ্রেজেন্টেশন করবো সেম, প্রেজেন্টেশনটা সেম, তারপরে অর্ডারটাও সেম। আগে তো 2000
working in the grade pay of rupees 2000.
হ্যাঁ,
It was enhanced to rupees 2000.
400 under MA on account of MA.
Account of MSC এটা ওইটা ঢুকবে না।
ওখানে এখানে শুধু 2000 টাকা
Correct, MSC ঢুকবে। তাহলে তো ফাঁকাই রেখে দেবো।
ভুল করেছি দেখো তোমার
কে?
তুমি
না, ওটাই তো সব খুলে বেরিয়েছে যে ফার্স্ট পেজটা।
দেখে নিচ্ছি।
অরিজিনাল অ্যাপ্লিকেশন আছে এটা। এইটা মানে ওইটা।
বাসা দ্বারা জনের ক্ষেত্রে why you have handed over this order, Mr. Rai? Basra in case of another person?
না না, তো ও আলাদা। ও মামলা করেছিল কোর্টে।
ঠিক।
কোর্টে মামলা করতে ওকে আবার সুপারি পোস্টে ঘুরে দিয়েছে।
Oh, my lord, yes, my lord, that was annexed in the original application where after we filed the original application before the tribunal, my lord, they once again, my lord, kept us to the supernumerary post, accepted our case, and my lord, sent us back in a supernumerary post. So I, my lord, attach that instances.
On the one hand, he denied supernumerary post.
Who denies?
The other hand,
I never.
but that judge,
Post of Hammer.
no, that judgment, my learned friend cited, there the lower post was accepted and authority refused. And here, after filing the application, authority automatically gave him, created supernumerary post.
We would not have even come before the
And no
tribunal.
problem. It is some way conflicting. Anyway, my lord, since your lordship has already arrived at a conclusion, I have nothing to improve.
What you are saying, Mr. Vajpayee, that he was given a post of housekeeping.
No,
He did
not here.
Huh?
My lord, the judgment that has been referred by my learned friend, my lord, there it was
He
given,
accepted.
he accepted without prejudice, and subsequently the alternative post was refused. Suitable alternative post
No,
in
it
the
was-
judgment.
You refused.
Yes, by the
So they
authority. So they came up. By the authority,
The authority took a stand that once you have joined,
yes.
you cannot come back.
And here the same authority, even after filing the application, created a supernumerary post and,
My learned senior is,
Bhaskar.
yes,
Bhaskar.
yes.
my lord, he is
So the
supporting my
question
case.
is, my lord, that authority is not deliberately doing so. On the one hand, by filing application, he has, the post was searched out and given. And the post was not available then, but given by creating supernumerary post. And the other hand, the rejection order, because there may be some other reason, but I
No, you have not gone.
my lord, my lord.
সদরটা ফার্স্টটা সদরটা
কতটাই তো বলি।
অ্যাকচুয়ালি সেটা হ্যাঁ অ্যাকচুয়ালি
Dono actually,
মান্থলি লিস্টের অ্যাকচুয়ালি দেখুন
আর এইটা কত? এটা হচ্ছে আপনার সোমনাথ রে একটা হয়নি, লিটল বিট ডিফারেন্স হচ্ছে 17 ওটার মতো 16
What
হলো
is 70?
My lord, here, my lord, I was head constable. I was head constable. But after my lord, disability accrued, I was suggested that I should be given appointment in a sedentary post.
Sedentary post.
So after that, my lord, they have just given me appointment in the same grade pay. In this case, my lord, they did not lower my grade pay. In the same grade pay as a carpenter. I was said that I was decided that my left hand was not working, right hand and left hand. One of the hands are not working. If I can take your lordship, I just hand up your lordship at first the original applications.
The same order was passed.
My lord,
Order passed was same. That 1304.
Same
You
order.
are entitled to.
Yes,
Oh,
suitable.
here it was 1304. 1304 was not in the earlier cases, but that paragraph was quoted.
Quoted because all these matters were being taken up together. But if I can-
It is offered in post staff and admin. So they have now placed you in the post of
My lord, your
Carpenter
lordship will
2.
find
same
Carpenter,
grade,
page number
same grade pay alternative post.
page number
same
15.
grade pay alternative. Now what does he want?
Now, he is saying that since my hand is not working, I cannot accept that. You are to give me as per my choice.
Then what did you do?
Nothing. We are searching for suitable alternative, nothing. What we can do, my lord, I cannot improve the case any further because they are asking that carpenter 2 is not my post. You give me the post of my choice. So well, even if the alternative post is given, the choice should be is given that no, this post, that post I want desk work.
That becomes a new issue that this order is bad. Tribunal did not consider the issue at all.
My lord, does your lordship, if I can take your lordship, my lord, page number 15 of the original application.
No. Herein you were given the same grade post. Now you are not joining on the ground.
It is not
That
suitable to
one,
me.
huh?
It
That
is not suitable to me.
Yes. When it is not suitable, the court is to adjudicate the suitability on the basis of the 1304. But that had not been the line of the judge.
Lordship will kindly seize this, the order which is assailed in this matter.
Same order.
No, my lord, kindly seize this.
Same order.
My lord, it is, my lord, said that the suitable, if I can place your lordship to that.
That is your content, sir.
My lord, kindly seize. It is there. Page number 2, internal page number 2 of the impugned judgment. Which starts, my lord, paragraph number 3, the bottom. May I, my lord, please? Learned counsel for the applicant would submit that the applicant was working as head constable in such and such and that he was such and such. That on 29th of March 2022 was sent for medical examination and he was diagnosed to be suffering from surgically intervened post-implant removed old case for fracture, such and such right side with stiffness in right elbow. That despite such diagnosis, the applicant was recommended to be posted as carpenter 2 in grade pay such and such. That the applicant via his communication had expressed his unwillingness to resume his duties as carpenter 2, had instead prayed for other desk-related jobs. The authorities, however, communicated their regret via 30th September 2022. Thereafter, my lord, paragraph number 4, where my lord 8999 comes. My lord, if I can take your lordship directly to paragraph number 6 after that. And the reasons, my lord, are, my lord, trying to find out, your lordship will find at paragraph number, I'm sorry, internal page number 5 of the impugned order. The second paragraph.
The judgment referred to in paragraph 7
My lord.
does not relate to similar impurities.
But it does, because it is, my lord, again, with respect to consideration of the representation by an one-liner, by saying that you are regretted, no reason.
Sorry, that
My lord, lordship has just only see internal, lordship is on internal page number 5. Paragraph of internal page number 5. It is disclosed from the above diagnosis that the applicant has been advised not to lift heavy weight using both upper limbs and such reported old history of such old seron and stiffness with such. A carpenter, that the finding, a carpenter to jobs.
may not do. Finding is may not do.
My lord, yes, I tell your lordship, carpenter 2's job involving flexibility on the right elbow and use right upper arm may not be the appropriate alternative appointment as in the case of the applicant despite the committee's recommendations thereon. So I'll be relying upon their recommendation. If I can take your lordship to that. My lord, page number 15 of the original application. Original application.
That recommendation was in your favor.
15, my lord. Serial number 3, lordship found. Somnath Rai. My lord, if I can take your lordship to 1, 2, 3, 4, 5, 6th column, and a fit for medical category, lordship has found in the middle of the page. Fit for medical category. Yes, my lord, he said he is suffering from such and such. His medical condition is not fit in his present job as head constable RPF due to disease from which he has been suffering. He is fit for job which does not involve lifting or heavy weight using both upper hands, limbs and firearm duties. Duties with firearm may become detrimental to himself. The employee should perform sedentary nature of job.
That is what was given to you.
My lord, sedentary, it's a carpenter job, my lord, I have been given. My lord, subject to correction, my lord, sedentary nature of job means a job
Which you will sit and part.
sitting, by sitting doing that. I was just, my lord, going through, my lord, the lexicon of IRS. It is not there, but my lord, the Black Law Dictionary, my lord, says about sedentary job. No, it doesn't. But here, at best, my lord, I could find the, my lord, the meaning of sedentary. No, not sedentary. So I did not find, my lord, the sedentary job, but it says in the Oxford Dictionary that it is a job with by sitting in a desk that can be done. So here, my lord, I have been given a job, my lord, for doing a carpenter, and my one hand is not working.
I have not seen
So
any
here-
carpenter jumping.
So here, so 1303, lordship has seen, specifically it has said, both 1303 and 1304, that the job has to be there in a suitable medical category, where I can adequately fit. So this is why, my lord, the learned tribunal has come to this conclusion that this particular job is not suitable for this particular gentleman.
I have not seen any carpenter jumping. Everybody is sitting and doing job.
Jumping.
So he sits, but he moves his hand.
A heavyweight question does not. Anyway, other alternative post that was available, that was given. Anyway, my lord, I am not.
Upon considering, remarks Since he was suffering from the competition was also facing in a sedentary facing a post apart from sedentary nature. And as such, the tribunal arrived at a finding that post which he had offered, which he was offered, is not suitable. Not suitable. Considering gravity versus suffering.
Have my lord extended any time frame for compliance with the order of the learned tribe?
We have not interfered. Go and take steps.
Yes, my lord, I've already done. Grateful. But in these orders, my lord, let it be recorded, or the original application be kept in this record. Copies.
হ্যাঁ, এখন এইসব মামলার কোনো এ আছে? চলো, আমি খাইনি।
But 18 and 19 both are same matters.
Land result করে। এই চশমাটা এখানে
Yes.
পেলাম।
এই তো। না, সোনার চশমা স্যার।
হ্যাঁ। আচ্ছা, আইডেন্টিক্যাল?
হ্যাঁ।
দুটোই দিয়েছে, দুটোই দিয়েছে। May I request your lordship to take up item 19 because I am in item 19. Both are same matter, item 19 and 18.
Take the 18 first. 18টা করো না।
19 টা আমি আছি, 18 টা
নোট গুলো
করে নিচ্ছি, পেজ মার্ক সব দিয়ে দাও।
There is a direction for filing affidavit. That is.
What they have said in their evidence.
Nothing new. They have said only one thing. If your lordship kindly comes to their opposition. 18, he is appearing with Mr. Shumo Mojumdar. করুন না, 18 থেকে করুন। লর্ডশিপ কাইন্ডলি হ্যাঁ, ঠিক আছে বলে দিলাম। এই যে একই তো, ঠিক আছে।
18 direction was to
Mr. Bhattacharya, you are in 19 also.
Yes.
the direction of the learned tribunal was in the original application to consider their case.
This is my
They are,
opposition.
they are covered by the RB 99 of 2010, which says that six of providing employment to one of the family members of the landlord. Now, learned tribunal directed them to consider in the light of the decision of this honorable court in WPCT 274 of 2016. Now, that was not done. These, so far these petitioners are concerned, my lord, they were not even provided with the prescribed form for applying for employment. Because one of the family members is entitled to apply. Now, we filed contempt. Contempt application, they are altogether, my lord, 43 contempt applications were taken up together. This, including the contempt petitions of these petitioners. Now, learned tribunal held that since they have initiated the process, so sufficient compliance is there, though the contempt applications are proceedings are dropped.
So, first order for consideration is culminated in any order.
No, yes, thereafter, my lord, they did not consider.
So that earlier direction was not
Considered.
That is, who was that ordered first?
Yes. That is, my lord, starting from page 150, 150. If your lordship kindly comes to 170, page 170. 170. Order, internal page 21 of the order, original order. Altogether 73 petitions were disposed of by that.
পেজ মিলছে না তো এটা নির্মাণের সাথে পেজ মিলছে না না নমস্কার মিলছে আমার তো 170 তো বলছে যে অর্ডার
পরের পেজটা 19 টা দেখ
পেজ
150
তো পরেরটা
terminus order.
পেজ
Page 150.
পেজ 150 টা মিলেছে পেজ 150 তো মিলেছে এই তো তাই বললাম
Ashish Nath's case was also disposed of by the said order.
Where do we find his name?
হ্যাঁ পেজ 170 থেকে বলছে
Just a minute.
Asisna, page 159.
Yes,
Yes, what do you want us to show?
page 170.
170.
Yes. Paragraph 7, 8.
Yes.
But from the records, we discern the following. That inarguably and indubitably, the applicants are the land losers whose
Mr. Doctor, we are wanting to, your contention was there was a direction for consideration of a case in terms of a particular art. Where is that order?
yes,
Order which you alleged violation.
yes, page 172. Yes. Paragraph 10.
171 থেকে দেখাতে হবে
Paragraph
10.
পেজ 171 প্যারা 9 starts from that
No, no. Page, paragraph 10. In view of the direction of the Honorable High Court Supra and our revelations as indicated above, we feel it appropriate in the interest of justice to direct the respondents to undertake an identical exercise as directed by the Honorable High Court in WPCT 74 of 2016 and issue appropriate order in regard to the present applicants within 4 months. Now, those petitioners in WBC, I know, 74 of 99, 2016 were also land losers. There,
This was your first order.
yes, against which the contempt was filed for non-compliance.
Our regulations, we feel it every get respondent to undertake an identical exercise where Justice Dotto said that even paid.
No, this is not a paid. Our case is that we are not even provided with any form. No process was initiated in our case. Nothing. No, not even the form. After the form is given, we will apply. After application, they will consider a document verification, then medical. That stage has not come. Only first prescribed form for applying. One of the family members will apply.
Where is that?
That is in. That is.
Where is that in the order of High Court? Page 172.
174. Lordship, kindly come to the
PCT 74.
Yeah.
This was the order at page 174.
4.
আবার বলে 172 it has been quoted.
Yes.
It is quoted.
They are also.
Was there what was the direction? Because your representation was directed to be considered as directed by High Court.
Yes, that is page 170. High Court's order is page 174.
Did not go to that page 170. It has been quoted, no?
Yes. Yes. It is evident from the materials on record that the even land losers who are 47 years old have been offered appointment. The respondent number 1 is 46-year-old on the date of he approached the tribunal for the first time. When his claim was rejected by the first order dated such and such, age bar was not cited as a ground. Therefore, what we find is that there were absence of certain documents, papers for which the claim of the respondent number 1 could not be put up before the screening committee for screening. If indeed that was the reason for regretting his prayer, the petitioner ought to have asked the respondent number 1 to supply the documents which are not there in the file. Instead of closing his right to claim appointment, we therefore propose to pass the following further directions to close the breach. Within a period of 7 days from the date of receipt of a copy of this judgment and order, the chief personal officer shall intimate the respondent one which of the documents be required for his end, from his end, for ensuring placement of his claim before the screening committee. Within a month of receipt of such,
So this has not been done.
nothing has been done.
So they have not given you documents.
Nothing.
They have not.
As for they have to supply first the prescribed format where one of the family members will apply. That was also not given. Because of the fact.
That was not the direction. Direction was within 7 days. The chief personal officer intimate the respondent each of the documents are required from his end for ensuring placement of his claim.
Yes. Yes.
Where is the direction that prescribed performance?
No, that includes prescribed form because unless I am allowed to apply, my lord, the screening committee, the first document is the prescribed format. They have to apply.
Where have you stated in your content application?
Nothing has been, we have stated nothing has been done after the order, nothing. They are sitting tight. Now railway stand is different in my lord. Railway is saying that the land was acquired by the corporation, so we have no responsibility. Corporation says we have no responsibility, land was acquired by them. Now, Lordship, kindly come to their opposition for a moment with paragraph 21.
So we will reopen your content.
Yes, Lordship, kindly come to page 20, paragraph 21 of the opposition filed by.
That is my prayer also before Lordship.
Mr. Dotto, are we required to go into that?
Yes, my lord, because of the fact, my lord, tribunal said that since the process has been initiated, so there is substantial compliance, so continuity is dropped.
That is which paragraph?
Yes.
Impugned order type. Impugned order.
Yes, impugned order.
Page কত?
Where is the input?
When your lordship will get is perhaps one of the last page of this writ petition, subject to correction.
235 of this P7.
235.
সব বলবো আসছে একটু
এটা তো এটা তো taking into consideration page number নেই ওখানে কিছু that is why no ও তো বলছে
page
How many contents were decided?
43.
43.
Yes, page 276, my lord.
But here it is 49, Mr. Dutta.
maybe
Order impugned is 18th April 20.
Yes, sorry,
Yes,
sorry,
yes.
my lord. Yes,
49
When was it? It was reserved for judgment.
yes.
কোথায় পাবো?
My lord,
It is not written there.
the matter was, I was present in the tribunal when the matter was heard for the DFCCIL. The matter was heard for a lengthy period of time. There was a change of member and it was last heard on 21st December.
In the tribunal, my lord, they don't mention the date of hearing and the date of order. Only date of order.
The matter was last heard on 21st December 2022 and the order was passed in April 2023.
কে বলছে সব কিছু করবে?
বলবো পরে আছে তোমার অধৈর্য
So, Mr. Doctor, why didn't you tell the court that the order has not been complied with?
Yes,
You stated that.
in our contempt petition, you have stated in our case.
Your submission.
No submissions were recorded.
No, it
Even
is
our submissions were not recorded.
no submissions were recorded. Only all the petitions were treated alike. Because in some cases, my lord, no, lordship kindly,
Submitted this, you have not recorded.
no, lordship kindly see page 276.
Well, it is the usual habit of the judicial member not to record the submission.
Page 270, paragraph 276, paragraph 29.1.
Is a judicial decorum.
76.
Yeah.
May I please, my lord? Paragraph 29.1. Undisputedly, the respondents have possessed the case of the candidates as per the direction issued by the High Court as well as by this tribunal. And as per medical category fitness certificate of the applicants, he or she has been offered employment by the respondents. If it is not in dispute, the competent authority in terms of RBNM has granted permissible relaxation to the applicant. As such, the process, their application and thereby substantially complied with the directions brought for compliance under the content jurisdiction.
All right, now show in the content application where you stated that nothing has been done. Have you annexed contempt application?
Is yes, very good.
Where is your contempt application?
Thus you will find at page 120.
Page 97, it starts. Which paragraph you have stated?
Page কত? 97 হচ্ছে contempt application.
Page 90.
We come to 112. Page 12, paragraph 12. To communicated the order.
Yes.
On 3rd of August 20. Very good. Then para 13. Where you have said that forms have not been given. You did not comply.
Nothing was done in order.
It was done, it has to be stated, Mr. Dotto. In the contempt, if there is no pleading, what relief we will give you? Now the order was passed, that consideration order was passed in terms of the High Court order, that, or what was the date of that order? The page 174, huh?
Page 174.
Page 174. It was on, that was WPCT order was on 8th February 2019.
Yes.
When was the tribunal disposed of your?
16th March 2020.
Where is that you should take?
150 of my brief, 150.
150.
March 2020.
The final order
Yes.
is the order on contempt, which you have challenged here.
No. This is way, 150.
Oh. So this was disposed of when?
16th March 2020.
This was the original order in the OA directing your case to be considered in terms of WPC. So this order was 16th March 2020. When did you file the contempt?
Content was filed.
If you don't make a list of dates, Mr. Doctor, it becomes very difficult.
10/2/2021.
What do you do?
ये ना, ওটা কোনো কথা
Mr.
না।
Doctor, we cannot proceed in this case. Please make a, this is a voluminous case.
Now dispute revolves around only one point, my lord. Who will do this? Now, in their opposition, the Eastern Railway authorities have filed paragraph 21.
We are not concerned with that. They will take that point before the trial.
They have taken.
Yes.
They have taken.
The tribunal will decide. Why should we decide? We will reopen the proceedings and send it back.
No, in one case, this honorable coordinate bench of this honorable court, my lord, considered this order, particular order in contempt, whether they followed the directions as per order of this honorable court in the WB 74 of 2016.
Well, what did they say?
Now, that is annexed to my reply, my lord.
My sister was there.
Yes. Page 13 of the
So the supplementary evidence, why you have filed?
some documents were annexed to show that it was acquired by the railway.
Next, where do you have it?
Reply, evident reply. Page 13.
So, Mr. Doctor, let us start from here. Objection for consideration was there. Your contention not considered. I did not even get the form.
Nothing.
To that effect, you filed a complaint.
Yes.
Contempt proceeding was dropped.
Yes.
What is your grievance? That you are reserving the judgment and thereafter you are not recording my submissions and you are disposing of the contempt.
Not only that, my lord. They are saying that we have been considered. They have substantially complied with because they have considered our case.
So that is to be adjudicated by the trial.
Lordship, if your lordship demands, it will take another 2 years. That is
cannot be a ground for
that is the
asking
problem, my lord. Lordship kindly consider. Now
what is the order passed by the
page 13 of the evident reply. Page 19 is the lordship, if I point to place.
Dismissing contempt was dismissed.
Yes, dropped.
It was dropped, not set aside.
Yes, no. Here, my lord, it was set aside. Order was set aside.
So comply. Very good. Pass on. Considering healthy comply and pass this or that.
Yes, yes. Now, only thing, my lord, there's a problem. My learned friend is appearing for the Freight Corridor Corporation. He is saying that we have no responsibility, railway is the responsibility. That's why I wanted to 21.
Paragraph
21. And the same problem will remain.
This opposition is filed by the
Eastern Railway.
There, since there was no direction upon us, we have not used any opposition.
May I place?
No, direction
Page
from the very initial stage.
Page 21, paragraph
Only the
21.
Railway authority has filed.
Paragraph 21. That so far as the petitioner is concerned, admittedly, we never admitted. His land has been acquired by DFFCCIL under the special railway project, namely Eastern Dedicated Freight Corridor, and also covered under schedule of lands mentioned there in the notification dated 12/2/2013. Therefore, petition is not entitled in relief from the Eastern Railway Authority. Now, I just draw your lordship attention to one document. They are saying it has been acquired by the Freight Corridor Corporation, so we have no responsibility. It will be complied with by them. Now, lordship, and it has been acquired by them, not by Eastern Railway. Lordship, kindly go to page 37 of the writ petition.
who is he?
Well, I am the dedicated freight corridor
Corporation.
corporation. It's a project corporation. It's a corporation running project under the railway board. Whenever we are assigned to do one project, we are constructing the project.
Freight corridor.
Dedicated Freight Corridor Corporation of India Limited.
They are executing authority of
We are the executive authority of any project.
You have not.
No.
Now, lordship, kindly go page 37 of the content.
It has to be given by Eastern.
Because there is a railway board specific circular that
Page 37 of the writ petition, my lord. Notification. They are saying that corporation has acquired. We have not acquired, so we have no responsibility. 7. This is a notification by the Minister of Railways. 7 of the writ petition. Ashish Nath, WPC 92.
May I hand over a copy?
No. Yes.
This is the notification of acquisition. This is the notification.
Page 37.
Yes, of the writ petition, my lord. WPCT 92.
Yes, 92, page 37 is a part of the page 37.
No, 37 running page, writ petition. Writ petition, my lord.
Yes.
Balcon.
Page 30. Yes.
Who has acquired the land? Lordship, kindly see. They are filing an affidavit with your lordship by saying that we have not acquired, the corporation has acquired. Ministry of Railways. In excess of powers conferred by subsection 1 of section 20A of the Railways Act 1989, such and such. Central government, after being satisfied that for the public purpose of the land, the brief description of which is given in the schedule, our land is there. Annexed here too, is required for the execution of special project, namely Eastern Dedicated Freight Corridor in the state of West Bengal, hereby declares its intention to acquire such land. There's no,
Mr. Dotto, how can we, what do you want from us? Tell us.
no, Lordship, if your Lordship directs that you comply with the direction as this order, as the same order as passed by this coordinate bench, now they will say we are not responsible. Now Lordship can observe, clarifies that yes,
You're right, but how can we make that observation? We are
we,
sitting in judicial review or L. Chandra Kumar's case.
that is true, my lord, your Lordship, and Article 226, Lordship has the power.
So we will, how can we declare, Mr. Dotto, that they cannot take this stand? We can record your objection, that having done this. And
No, your Lordship, they are filing affidavit with your Lordship by saying something which, if it is not correct.
So we are relegating the matter to the commission, reopening the contempt proceedings. Okay. And we will record your objection.
No, but if they say something in it by affirming an affidavit, whether that is correct or not, your Lordship can make an observation because they have stated on oath. No, it has been acquired by the corporation. And I have shown that it is not acquired by the corporation.
Yes, what is yours?
Your Lordship kindly, what is following for your Lordship? Your Lordship kindly come to my page 10 of my opposition. That is my ultimate submission with your Lordship. Page 10 of my opposition. Paragraph, page 10, paragraph, my Lord. Go on, paragraph 3. So I have stated, I will place that. Has your Lordship got it, my Lord? I state that if after considering the pleadings in the opposition and also the order passed by the learned tribunal, dropping the contempt proceeding, this honorable court holds that the learned tribunal are dropping the contempt proceeding, did not take into consideration the point raised by the railway authority in proper perspective. This honorable court may remand the matter before the learned tribunal to consider a case.
That is exactly what.
That my Lord.
But what is your, Mr. Bhattacharjee, what is your
Stand.
answer to this? You
Yes.
have acquired.
Yes, my answer, no, my Lord. To that one, I have to place my opposition.
Tell us.
Yes, your
Let
Lordship.
us understand.
Now, your Lordship kindly peruse, my Lord. My opposition, my Lord, at page.
No, you tell us.
My Lord, the notification, my
The
Lord.
contempt application which was hard. Did you use any opposition in that?
My Lord, there only one affidavit was filed.
Did you
That
take-
was not also not properly considered. Since the proceeding was dropped, my Lord, we are not aggrieved. That is why we have not come before. That your Lordship, that your Lordship reopen, keep all point open, my Lord, we'll take that, they will decide, my Lord.
What points open?
Your Lordship reopen the contempt proceeding, we'll make our submission, we'll rely our records there, and the authority.
That you seek from the court after 10 years, you're coming and making out a fresh case, Mr.
No
Bhattacharjee?
fresh case, no fresh case, that is there, man. No fresh case. Everything is on record there, nothing new. Only on, which are on records, no other document.
That is for you to, we will say from the affidavit that the document shows that you have acquired the property. And in affidavit, you are stating that it is he who is responsible.
Man, that is my, that will appear from the memorandum itself and the documents relied on before the tribunal.
My lord, my lord. Lordship. Lordship, may I draw your Lordship's kind attention to the affidavit in opposition filed by the railways. Lordship, kindly come to page 7, para 16. Lordship, for my satisfaction, kindly come to page 7, para 16. May I read out?
Yes.
Kindly come to the affidavit filed by the railways at page 7, para 16. They are taking contradictory steps. It may be mentioned herein that by another letter dated 7/2/2018, written by Director Establishment M2 such and such, Eastern Railway, clarifying that Railway Board's letter dated 16/7.
We are not going into this.
No,
We are
Lordship,
simply saying, whatever problem you have, you fight it out before the tribunal.
Lordship, at least one, now they are telling that we have acquired the land.
Very good. Now to a determined content.
No,
Both of you
Lordship,
will be appearing.
Lordship, kindly record this. And by letter, it is applicable to Railway Production Unit and not to other bodies, including DFCCIL. They have stated in their affidavit that RB 99 of 2010 is not applicable to us. Therefore, we have no power to give any appointment.
So, Mitro, you are not understanding what.
Well,
we are-
I am also Mr. Dotto.
What we are saying is that today on the contempt proceedings have been dropped. Allegation is that my case has not even moved an inch. On the contrary, by filing an affidavit, you are taking a stand. They are taking a stand that I am not the author.
And in that
issue is for you to agitate before.
my lord, in that, if Lordship kindly record that in that same affidavit, they are stating that
If we say this, then they get a chance to reopen the entire proceeding. They will say, I will file fresh evidence.
no, well, Lordship kindly see.
No,
In that affidavit, on the same breath, they are stating that DFCCL has no power to give an appointment. Lordship kindly see. It is in the part of that same affidavit.
My only humble submission is this, my lord.
Lordship kindly
Before
consider
your lordship,
it is appointed by the
chief
same person.
the chief personal officer of Eastern Railway is filing an affidavit which contrary to the document.
And,
Before your lordship,
containing contradictory statements.
we were honorable High Court, if it is filed, which is by chief person, he is the HAG, Higher Administrative Grade Officer, and he is saying that it has been acquired by the corporation, not by us.
And,
Whereas the notification shows that it has been acquired by the railway.
What do you want from us?
Lordship, that on this affidavit, Lordship makes some observation because this is a false affidavit in my system. No, I am not saying.
Any observation, in that case, they get a better chance to come with fresh evidence in your court. Choice is yours. You want to receive the content.
No, if your lordship observes
Lordship, in a
that
same
land
affidavit,
was
they are
acquired by
taking contradictory
them.
stand, which is very much surprising.
The present restriction has been challenged.
This order may be quashed, my lord, set aside, my lord. This tribunal's order of in contempt.
Challenging an order to challenging an order dated 16th of March, sorry. Order dated 18th of April 2023. Passed by the learned tribunal in several contempt applications. Contempt application filed by the petitioner hearing. What is the number, Mr. Mr. Dottul and the advocate hearing for petitioner or petitioners?
My learned friend is for both the petition.
This is in item 19. Mr. Dottul and the advocate for petitioner submits that as the petitioner state for appointment under land user category. Yes, Mr. Satya, was not considered by the competent authority. Petitioner was constrained to prefer an original application before the learned tribunal, being with
493 of 2017. 493 of
493 of 2007. Said content, drawing our attention to the, where is that order? You place 174, na? Now,
Page
drawing
of-
our attention to page your original application was 350 of 2000.
CBP is the computer number, computer code.
493.
493 is the computer code.
Drawing our attention to paragraphs 9 and 7. And the same was drawing our attention to paragraphs 9 and 10 of the order passed in the said original application. Mr. Doctor submits that the learned tribunal rejected inter alia that it would be appropriate in the interest of justice to direct the respondents to undertake identical exercise as decided by the Honorable High Court in WPC of 2016 and issue appropriate order in regard to the present application, in regard to the petitioner's application. 4 marks. Stopping paragraph 9 of the paper. Objections issued by the Honorable High Court in WPC 74 of 2016 were quoted. Mr. Dotto submits that even after due communication of the order, not even the prescribed forms were supplied to the petitioner. This to say about compliance of the, not even the supplied to the petitioner, stop. In spite of repeated reminders, the respondents maintained deceptive silence. And as such, the petitioner was constrained to prefer a contempt application before the learned tribunal. Being CP, what is the number?
My lord, CP 36 of 2021.
The said contempt application was heard along with 48 similar contempt applications. And the contempt proceedings and the contempt proceedings were dropped, and the miscellaneous applications were, what was the miscellaneous application?
No, others.
Contempt proceeding was dropped. Observing inter alia that in terms of RBE 1999/2010,
My lord, observations start at paragraph 29.1.
observing inter alia that the respondents have processed the case of the candidates as per direction of the High Court, as well as by this tribunal and as per medical category, stroke fitness certificate of the applicants, this stroke she has been offered employment by the Mr. Dotto submits that such observation is contrary to the records. The alleged contemners have flagrantly violated objection of the learned tribunal and their claim has not been considered. Drawing our attention, and Mr. Dotto further submits that similar writ petitions were filed challenging the order dated 18th of April 2020, challenging the order dated 18th of April 2023. And a coordinate bench of this court had, upon contested hearing, had set aside the orders of the learned tribunal dismissing the contempt petitions, directing the respondents to comply with the order dated 16th of March 2020. Your order was that 16th March.
Same order, same order.
Yes, 16
Same.
months, same order.
By adopting identical process as adopted for the petitioner in WPCT 74 of 2016. While considering the claim of the petitioners and pass orders within 4 months. It was further observed that if the respondents fail to comply with the order, it would be open to the petitioner to mention before the tribunal for reopening the contempt petitions. Stop.
Subsequently, the last part was modified to the extent that the contempt will be filed before this honorable court.
Subsequently, that order is modified.
Not tribunal.
That order then added.
Where is that order?
That order is, that is modified order is not.
Yes.
I had a copy. I had a copy.
The said order was subsequently modified by the said coordinate bench by an order dated 9th August 2023. What was the modification?
The contempt will be filed before this.
Where is it?
You order this is though.
If you fail to comply, to open to for reopening of the complaint. At the time of typing, important get sent for the last paragraph. What to approve this court has not been.
Earlier it was tribunal.
Open to the petitioners to mention before the tribunal or to approve.
আচ্ছা আরেকটু কপি আছে।
Bid order was subsequently modified.
Modified by the
একটা বই পেয়েছি।
modifying the last paragraph at internal page 7 of the order.
Bid order was subsequently modified by coordinate bench
And
by order dated
No. the last paragraph of at internal page 7 of the order was subsequently directed to be modified as follows. Course of hearing. In course of hearing, liberty was prayed for by Mr. Bhattacharya, learned advocate appearing for Eastern Railways, and by Mr. You have not filed. You have not filed anyone.
I have not filed it.
Liberty was prayed for by Mr. Bhattacharya, learned advocate appearing for Eastern Railway to file an affidavit in opposition. So the same has been filed, and a reply to the defect has also been used by the it is the contention of Mr. Bhattacharya. Did you file any opposition in the contempt?
Yes.
That I can say.
Same stand was taken.
Same stand was taken.
That is the
Same
stand,
stand was
same stand.
The documents are there, my lord.
Supplementary affidavit, I have annexed, my lord.
But that these documents are
Yes,
there,
yes.
no new documents have been, that has not been considered also by the country.
Same chief personal officer, same chief person.
That we have not acquired the land.
Nothing reflects from the order, my lord, that this was considered.
Let me stop. Mr. Bhattacharya submits that a similar affidavit was affirmed before the learned tribunal, but the same was not taken into consideration. You have also
No, I have not used any affidavit. I have only relied upon a document. No, I have no, in tribunal, I have not used any affidavit. I have only relied upon a document.
our attention to paragraph 37 of the said affidavit in opposition. Mr. Bhattacharya submits that the land has been acquired by PFCCIL under the special railway project, namely Eastern Dedicated Freight Corridor, and also covered under the schedule of lands mentioned therein in the notification dated 12th of February 2013. And the petitioner is not entitled to, as the acquired land is not coming under the jurisdiction of the general manager. Mr. Dotto, learned advocate appearing for the respondent number
5, DFCCIL. Respondent number 5, DFCCIL.
Respondent number 5 hearing. Which document you showed us?
Page 7, para 16 of the affidavit filed by Eastern Railway.
Happens that in the affidavit affirmed on behalf of Eastern Railway, contradictory statements have been.
Yes,
Though it has in paragraph
16.
16, though it has been stated, in paragraph 16, it has inter alia been stated.
First paragraph.
Inter stated that by a letter dated 7th February 2018, written by Director Establishment Secretary M-Roman to Railway Board, addressed General Manager, Capital Eastern Railway, clarifying that Railway Board's letter dated 16 July 2010. 16 July 2010 is.
That is RB 99 of 2000.
That is the scheme, my
So that
That
is
is
the
the
No, you showed us that notification.
page
notification,
46, Manoj, page
page
46,
125,
page 46 of
page
the
125 is the,
of the read petition. I have referred in my paragraph also.
page 46.
46.
Your lordship get it from my paragraph 16, last line. I have referred this, and your lordship will get it
Page 46.
of the read petition.
In opposition, you have not written.
I have, your lordship kindly peruse my paragraph 16, last line.
Paragraph 16 of the
Paragraph-
opposition.
of the opposition. Last line, your lordship kindly pardon.
Issue appropriate order.
No. Page 7, paragraph 16. That
Your opposition.
yes. The
Yes.
copy of the letter is appearing at page 46 of the supplementary affidavit. I have referred that. So that
Supplementary
affidavit filed by the writ petitioner in this.
Oh, acha, acha.
That is a relevant letter.
Instead of bringing several documents, my lord, I have referred it.
So that document shows it has been acquired by you.
No, my lord, that is not that.
46.
No, the appointment scheme is not applicable.
Page 125 of the writ petition. Notification of acquisition.
No, there is.
হ্যাঁ সেটাই চাইছে
না, 6-7-2010 চাইছে। আপনি উল্টো
Page
পাল্টা।
125.
No.
No, your lordship is asking for the notification.
Customs code na, that they had acquired.
This is 125, page 125 of the writ petition. WPCT 92 of 2000. Writ petition. Notification,
Annex somewhere else also.
Yes, your lordship will get it. I give it to lordship immediately. My lord, page 37. My lord, page 37, your lord.
37 of the writ petition also. Page 37 of the writ petition also.
Mr. Dr. Learned Advocate appearing for the respondent number 5.
No, ওটা চাইছে না।
Submits that, no, এরকম দেখুন। It is drawing our attention to paragraph
21.
16 and
16 টা হচ্ছে প্যারাগ্রাফ পেজ 39 দোষ
16 and 21 of the affidavit in opposition filed by on behalf of Eastern Railway, Mr. Dr. Learned Advocate appearing for the respondent submits that a perusal of the said orders from a perusal of the amendments made in the said paragraph, be explicit that contradictory statements have been made. Stop. Mr. Dr. Learned Advocate, Mr.
Senior.
Learned Advocate. Learned Advocate also draws our attention, drawing our attention to page 125 of the petition to a notification dated 12th of February 2013. Submits that the amendments made in paragraph 21 of the affidavit in opposition are absolutely wrong. We have hardly learned advocates of this.
One fact, only one fact. The common order passed by the original application in 16 March 2017, that was challenged before this Honorable High Court by the railway authorities. WBCT 28 and WBCT 75. That was also dismissed. Same order.
That order has been upheld by this honorable.
That considered which
That original order.
Original application order. Analogous order.
That has been referred. That has been referred in the
Already I have an.
Mr. Dr. submission. Mr. Dr. further submits that the order dated 16th of March 2020 passed in the petitioner's original application.
All original application.
All
Yes, including the petitioner's way.
petitioner's original application and the other applications was challenged before this court. And by an order dated 1st of July 2021, a coordinate bench of this court had rejected the said application. Why it was, what was argued before?
That is preferred by the railway authority. Southeastern Railway Authority challenged that order.
They did not challenge.
No, Eastern, not Eastern. There is an analogous matter. Eastern Railway, Southeastern Railway, there is so many projects in the Southeastern Railway Authority challenged.
Southeastern. Basically ordered dated first July 2021 as produced. The under advocates agreement considered. You have annexed that coordinate bench order where?
Reply.
Reply to annex correction. Case 13.
Yes,
Right,
sir.
sir? Case 13 affidavit in reply.
Last question for it and all.
It appears that neither the amendments made in the contempt application by the petitioner hearing that the amendments made neither were taken into consideration by the judge. In the contempt they filed opposition. In the contempt they filed opposition.
Hey, may not one opposition file করেছিল না?
No, no, no.
কোথায় contempt এ? হ্যাঁ,
Not contempt in this.
contempt এ জিজ্ঞেস করছি, just-
Contempt. হ্যাঁ,
করেছিল? Contempt, yes, they have filed.
Stuff. We do not find any. We have not been. We could not find any document. In this.
Opposition contempt opposition
ঠিক করে জেনে বলুন contempt এ কোনো opposition file করেছিল না শুধু affidavit টা করে?
কোন কোথায় ট্রাইব্যুনালে?
হ্যাঁ?
হ্যাঁ।
করেছিল?
Annex করে দিয়েছে।
Position টা annex করে?
supplementary affidavit.
Action to consider the petitioner's claim in terms of the order passed in WPC 74 of 2017 does not appear to have been taken. In similar facts and circumstances and in similar facts and circumstances, the coordinate bench of this court hearing the consideration was that they took time for compliance. They said that we will comply.
We comply, but
And this order was in this order. This was Eastern Railway was there. Eastern Railway was not there.
no, no.
So,
But same order, same issues. But tribunal's observation was that they are substantially complied with because they have initiated the process.
in the conspectus of the said, in the conspectus of the said facts, the observation of the learned tribunal in the order impugned that the petitioner's application had been processed and there has been substantial compliance of the compliance of the earlier order is not acceptable to this court. In view thereof and taking into consideration an order passed by a coordinate bench of this court in a similar matter, the
এখানে তো ওই পয়েন্টে ডিসাইড করা হবে না যে রিয়েল করবে না তো ডিসাইড ওই ডাইরেকশন
order
দিলে
dated such and such. In similar matter,
In our case, this is not similar. Our case, this is not similar matter. That is. Our case, this is not similar matter. That is why you have come. Our case, matter, this is not similar.
in a similar matter pertaining to the Southeastern Railway.
land losers.
Southeastern Railway. All right, Mr. Bhattacharya. We ordered impugned, the order dated. No, no. Into consideration, the order dated 11th of May 2023 passed by coordinate bench of this coordinate petition challenging. No, but we are not going that Southeastern, we are not saying, we are saying challenging the order in the contempt, challenging the order dated 18th of
April.
We set aside the order dated 18th of passed in the contempt application or passed in the petitioner's contempt application. Contempt application, we further read.
बोलने में मुश्किल है जाए वो स्टूडेंट
The respondents to comply with the order dated 16th of March 2020 by adopting identical processes adopted for the petitioner in WPCT 74 of 2016 while considering the claim of the petitioner and pass order within 4 months from date. In the event the respondents fail to comply with the order, we open to the petitioners to mention before the learned tribunal for opening the contempt petitions or to close this court to the where is that single page order? Or to approach with the above observations and directions. The petition is disposed of. There shall, however, be no order as because.
My lord is directing the tribunal to consider afresh, my lord.
We have directed that adopting the process of 74 similar steps.
And your lordship kindly, my lord, I have prayed for, my lord, page 10, paragraph Roman 3, my lord, that your lordship kindly, if after considering my opposition and their pleadings, that your lordship feels that this issue should be remanded to the tribunal, my lord, for fresh.
not application our application
The above observations and directions to the petition. Other one is also same.
My lord, the opposition.
The names are of same.
developed
DFCCIL টা লিখে যাও।
Same. I
18 and 19 same.
Same.
Original
রেখে দাও অভিজিৎ।
and CP number and
number and personal application number. এটাই ওটা ছাপিয়ে
order date same only.
রেখে দাও।